Section 88 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Dr. Valorus P. Coolidge for the murder of Edward Mathews, Maine, 1848, Part 7. March 21st. Mr. Evans. I hold it to be impossible that the body could have been taken from Dr. Coolidge's office through the alleys to the cellar without having disturbed the cloth on the cutting table, or in some way altered the arrangement of the chairs or rubbish in those alleys. The body was never taken down that stairway. It could not have been from the very nature of the case. It was placed in the cellar through the outside door. It must have been, I hold. It could not have been otherwise. What could have induced Flint to endeavor to fix this crime on his late tutor, I know not. I have not to inquire, nor will I suppose the hope of succeeding him in his business could have weighed with him in the matter. I will not attribute to him so base a design. There is enough on his account of wickedness already. Could I believe the whole of this testimony, Flint's and all, I would stand here and ask you to acquit the prisoner on the ground of insanity, for I cannot believe that a sane man, on whom character had ever stood unblemished, as the counsel on the other side are willing to admit, and as we could prove by thousands of witnesses were it necessary, would, in his sober senses, go about the commission of so awful a deed and scatter the evidences of guilt all around him. I reluctantly leave this subject, fearing, trembling, that I have but too feebly discharged my duty. Enough rests on me, but more on you, gentlemen. We are not in an ordinary court of justice. We are in a temple dedicated to the Most High God, where prayer and supplication are wont to be offered up to high heaven. The solemnity of the place and occasion should impress on your minds the importance of the matter which you are selected from among your fellow men to adjudge. When your verdict shall have been rendered, this vast assemblage will dissolve, to be called together no more on earth, but will again assemble, and on that great day, foreseen by the exile of Patmos, who in the record of his vision said, I saw the dead, both small and great, stand before God. I saw the books opened, and the dead, both small and great, were adjudged out of the books. When that day shall arrive, gentlemen, may you stand before the great tribunal unspotted from the blood of your fellow man. Mr. Blake paid a merited compliment to the eloquent gentleman who had just addressed the jury, remarking that the government always was required to make out a case in prosecutions of this description. He placed stress upon the circumstance that the body was found on the pile of wood in the cellar, dressed in clothes that were not soiled, as showing that the murder could not have been committed in the streets, which, it will be recollected, were very muddy at the time. The outside door of the cellar was open 12 or 14 inches, and could not be opened farther on account of the wood back of the door. The limbs were rigid, and it was with difficulty that the body, with the limbs in their original state, could be taken out through the outside door, circumstances which, in his opinion, went to show that the body could not have been put in the cellar through that door. Mr. Blake went on to the inquiry, was there poison in the body of Edward Mathews on the morning when it was found? In order to show there was poison, he reviewed the evidence touching that point. There could be no possible object in putting poison in the bowl which contained the contents of the stomach while lying behind the hogshead in Mr. Williams's shed, even if any person other than Mr. Williams knew it was there. In reviewing the testimony of Professor Loomis, founded on researches in books on chemistry, he complimented that gentleman's skill in his profession, and dwelt with considerable force on the improbability of his being mistaken in the analysis made of the contents of the stomach of deceased. March 22nd. Mr. Blake. I am inclined to think, gentlemen, that you entertain but little doubt that the stomach did actually contain a large amount of poison, as Professor Loomis tells you there was, under the solemnity of an oath. We therefore pass from that to the inquiry, was there poison in the body? We find that the brain was softened, that the blood had left the heart and was distributed through the veins, that the lungs were highly charged, and that in the lower part of the stomach there was a purple spot, indicating the presence of some corrosive substance. Dr. Hill and others, who did not see the body, say they should expect such appearances, but do not think them absolutely certain. Medical men who have experimented on the bodies of animals find similar appearances, just as they, from their experience, expected. It has been agreed that the food which animals live upon differs from that partaken of by men, but dogs live on animal and vegetable substances, and the appearances of the stomach in dogs experimented upon are exactly such as were expected. I acknowledge these indications are not quite as certain as that twice two make four, but they are very indicative of certain facts. Dr. Thayer and Dr. Plaisted discovered the odor of prussic acid in the brain of the deceased, and one of them in the thorax. Now, there is good proof that it was there. Dr. Smith testifies that he remembered the odor of prussic acid from having smelled it while a student 18 years before, and Dr. Hubbard tells you that he should consider the odor as certain a test as any other. These gentlemen are what the lawyers call experts. They were under oath, and from their experience and their standing in society are entitled to belief. Dr. Hubbard tells you that he has examined a great many bodies and never detected the odor of prussic acid in them unless put there. He does not believe this acid is ever generated in the stomach, and says, as does also Dr. Hill, that there is no respectable authority to prove the acid is ever so generated. I do not see how you could have better evidence than this of the presence of poison in a body unless you yourselves were to see the poison placed there. With regard to the quantities of prussic acid the prisoner had in his possession, with that he had already on hand, and that he purchased of Wales, he had more in his office at the time than he could have used in the course of his lifetime, without that purchased at Barnett's in Boston. What did he want of all this poison, and the bottle, too, a substance never used in the practice of medicine? What was the object? What was the design? If he had wanted it to prescribe for patients, would he have not got the 2% acid, the strength of which he knew? Mr. Goodwin tells you he does not know the strength of the strongest acid. Therefore, there is no point to start from in the dilution of it. Did you believe he wished it for dilution? This strongest acid is not safe to be used for any honest purpose of medicine. The prisoner must have known it. He did know it. Edward Mathews was seen to enter the prisoner's office on the evening of his death. He had then, as the prisoner himself says, $1,800. And the next morning he was found poisoned in the prisoner's cellar. Now, who killed Edward Mathews? If the story of Flint is not true, what is the truth in the matter? Why is it not shown where Mathews was on that night after he left the office of the prisoner? This is all circumstantial evidence, it is true. But could you have stronger evidence founded on circumstances than this? It is a truth that has been stereotyped in the experience of the world that murder will out. It may be a slight circumstance that the doctor said the poison would escape before the contents of the stomach could be got to Brunswick. But how did he know it would escape? Arsenic would not escape, nor would morphine. They would have remained for years. But prussic acid escapes readily. It is a volatile substance. And how could the prisoner have known that the poison, if in the contents of the stomach, would escape, unless he knew the character of the poison? Mr. Blake here cited two cases from Starkey on evidence, and the case of the state of Maine versus Sager, tried some 15 years ago, as illustrations of the kind of circumstantial evidence required to convict. The evidence in the latter case was not so strong as in this. Yet the defendant was convicted. Mr. Evans objected to such argument. He did not like that comparisons should be instituted in this case. The jury that convicted Sager had nothing to do with this case. He had a right to refer to the case, but he had no right to say how strong the evidence was without introducing that evidence as a matter of law. The court sustained the objection. Mr. Blake, Thomas Flint has under oath given you a detail of what he saw on the night of the 30th of September. It is a horrible tale, a frightful story, but I believe it to be true. Flint, after being called by the prisoner, went to the office. When there, the prisoner locked the door and, facing Flint, says, "I am going to reveal to you a secret which involves my life. That cursed little Ed Mathews came into the office, went to take a glass of brandy, and fell down dead." I will not attempt to describe the feelings of Flint. Thunderstruck, astounded, he remained speechless. After recovering somewhat from the shock, various modes of disposing of the body were suggested. Finally, it was taken to the cellar in the manner described, thrown on the wood, and left in the position in which it was found in the morning. Have we not made out a case here? I am sorry we have so done. I am sorry that a man whose prospects were so fair and who had borne such a good character should so have fallen. But the grand jury having found an indictment against him, it is right we should investigate the matter, and it is right the facts should come out. This testimony of Flint's is of the sort the defense tells you is the most valid. It is positive, and I do not find a single important point in which he is contradicted, but many in which his testimony is corroborated. What was his appearance on the stand? That certainly was well enough under the circumstances. Was it not exceedingly good? He was questioned as to the whole course of his life, and not a single circumstance brought out in the course of the cross-examination which did not show his character to have been good through his youth upward. Not a circumstance could be brought against his fair name up to the time of this transaction. The death being proved, the testimony of Thomas Flint alone is enough to convict the prisoner upon, and how much more weight ought to be attached to it if it is sustained by corroborative facts and circumstances. The prisoner was a man in good practice, whose character stood fair, a man much respected in the town where he belonged. When Flint came in and heard the astounding fact that the body of Edward Mathews was lying in the back room, he was struck with such astonishment he did not know how to proceed. He might have believed no murder had been committed, or if he did, was it safe for him to rush to the street and give the alarm had he desired to do so? There were blows upon the head of the deceased, and had Flint have given the alarm, he at the same time would have proclaimed his tutor a murderer. Had Coolidge any motive not to commit a second murder? And might he not have stricken him down had he approached the door? Had he the means? We know not. I know not what you would have done under such circumstances, but I pray God you may never be called upon to pass such a scathing ordeal. The conduct of Flint, gentlemen, is somewhat difficult for us to look at in the correct light. I believe that he either thought his friend and tutor innocent of a murder, or else that through fear he did not dare to divulge what he knew. He has been guilty of an offense, it is true, for which he has reason to repent in sackcloth and ashes. He has committed moral, if not legal, perjury by swearing as he did, negatively, it is true, before the coroner's jury, but the fear of implicating his friend and laboring as he did under the deepest excitement is some excuse for him. Men of nerve, perhaps, would have done otherwise. Perhaps they would not. After reflection, and after having seen his father, for it appears in evidence that he did write letters to his father, and that his father came to Waterville, he takes the proper course and discloses the facts in his knowledge, just as he ought to have done. The blame rests on him only that he did not make the disclosures before. The testimony of accomplices in crime should be supported by other testimony, most certainly. But Flint was not an accomplice in this murder. He knew nothing of it until after it was committed. He was an accessory after the fact, but not an accomplice. I do not know that anything I can say further is necessary in this case. I do not know that if I shall close here, I would not have performed my whole duty, but there are some other circumstances in the case which I will touch upon. Edward Mathews procured from the bank $1,500. He put it in his pocket, went to Charles Mathews' store, and there took a book of forms and commenced writing a mortgage. He took that book of forms, and with it in his possession, went towards Dr. Coolidge's office. Have you not a right to infer that the book of forms and the money had something to do with some transaction with Dr. Coolidge? We have it in evidence that Mathews went from the Parker house to the prisoner's office in the evening, and we have the confession of the prisoner that he was there, because he says he loaned the deceased on that evening $200. Well, he was in the office. Now, what was transacted there? The deadly potion was administered to the unsuspecting victim. With serpent-like subtlety, under the guise of friendship, was transacted this most heinous crime. After the deed was committed, the corpse was taken to the closet, but being found too small, the idea of placing it there was abandoned. The window was opened, but it struck the prisoner that blood might be found upon the casing, and that was abandoned. He went to the river, but finding it altogether unsafe to convey the body thither, he returned, went to Williams's, and there meeting Flint, takes him to the office, and the body was removed and deposited in the manner Flint has stated. This is the true state of the transaction. Circumstances prove it, and you cannot reasonably believe it to have been otherwise. The matter of character, gentlemen of the jury, is entitled to some weight. It has been testified to by 2 witnesses from Oxford County and 2 or 3 from Waterville that he did sustain a good character. But have not some circumstances been developed which tend to show that his habits were not altogether correct? He had a large practice, and of the most respectable character, yet we find he was most desperately pressed for money, and in one case offered $500 for the use of $1,000 6 months. He borrowed money of everyone who would loan it to him. His notes laid over at the bank. His income, though large, was not sufficient to procure him the luxuries he desired, and allow him the indulgence of those appetites and passions which had become pressing from habit. I acknowledge there is an absence of sufficient motive in this case for the commission of the murder. There even is an absence of sufficient motive for any murder ever committed. But a man was in the coolest blood murdered at Salem for $1,000. $1,000 was not sufficient motive, but the act was committed. The founder of our religion was betrayed for 30 pieces of silver. This was not motive enough for the commission of the act, but it was committed. Nor can character be always relied upon. For we know that Arnold, who had ever sustained a good character, proved a traitor of the darkest dye. And it must not be forgotten that Washington, who was a good judge of character, placed the most implicit confidence in him. Previous good character should carry its weight, but it must be weighed with caution. I invoke the jury, as honest men, to give a verdict such as the law and the evidence should dictate, without regard to the punishment that might follow. I can only say that should a verdict of guilty be returned, the prisoner would await in confinement his sentence 1 year, and that execution would then follow or not, as the public mind should dictate. End of section 88, read by Martha Weller, Champaign, Illinois, February 10th, 2024.
Section 89 of American State Trials Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Christine Bowden. American State Trials Volume 3 by John D. Lawson. Trial of Dr. Valorus P. Coolidge for the murder of Edward Mathews, Maine, 1848, Part 8. The charge of the court. Chief Justice Whitman adverted to the custom in cases of this nature of keeping the jury away from connection with their fellow men while hearing the evidence, and said he thought the course particularly correct in this case, where there had been more excitement and interest manifested than he had ever before witnessed. He explained by familiar comparisons what is meant by the term malice as applied to criminal actions, and told the jury that should they find the prisoner guilty, they must say whether it be of murder in the first or second degree, always remembering that the presence or absence of malice should form the basis of their decision. The sentence in one case would be death, at the expiration of 1 year's imprisonment, in the other imprisonment for life. In the present case, the last seen of Mathews was that he went to the office of the prisoner, and in the morning following was found dead in a cellar under the prisoner's office, killed by prussic acid. It was proper that the testimony should be carefully weighed with regard to the prussic acid as to whether the prisoner might not have taken or procured the acid elsewhere. The fact that persons seldom commit offenses without a motive should be borne in mind and applied to this case with all due force. In regard to the testimony of Flint, he desired the jury to consider whether, although he had perjured himself before the coroner's jury, in swearing as he had done, he had not gone contrary to his interest, and been forced to do it from compunctions of conscience. How much weight was to be attached to his testimony should be decided on this consideration, as well as on the basis of corroborative circumstances. The government had endeavored to make out a motive for the deed, supposing that the prisoner was in very embarrassed circumstances, while the defense had endeavored to show that he was abundantly supplied with money. The proof with regard to this point should be carefully considered. The prisoner had said that he had loaned the deceased $200 to be paid the next morning. What use the deceased might have for $200 for so short a time when he had $1,500 or more in his pocket was a circumstance entitled to some weight. Perhaps as strong a circumstance in the case as any the government had made out was that the prisoner had purchased a large quantity of prussic acid, some of which was not fit for the purposes of his profession. It would be competent for the jury to inquire for what purposes these large amounts of poison were purchased. It would be well to consider whether this sort of poison was kept by any person in the town of Waterville except the prisoner. No proof has appeared that any of the physicians or apothecaries there had it in their possession. Was it probable that the prisoner had put prussic acid in the bowl containing the contents of the stomach while it was lying behind the hogshead under the shed? Would he have any object in so doing? If the acid was put there, who could have done it? Who had such acid? For what object could it have been put there? These he considered weighty circumstances. He had full faith in the chemical tests of Professor Loomis and the other experts. Their testimony was entirely legal. There was a communication from the prisoner's office to the cellar. The prisoner's clothes were not soiled, as would probably have been the case had he been knocked down in the street. In considering circumstantial evidence, indications of this character had force which ought to be considered. The testimony of Flint was corroborated in some parts, in others it was contradicted. Whether the presence of Dr. Coolidge at the inquest when Flint testified falsely, if he had testified truly here, he had influence on his mind, or whether he was actuated by fear, should all be considered in weighing his testimony. Having touched on these prominent points of the evidence, and the circumstances growing out of such auxiliaries to the testimony in the case, he admonished the jury to weigh and amply consider each and every point, and return such a verdict as after mature deliberation they should find. Verdict and sentence. March 22. The jury, after an absence of about 24 hours, during which time they were twice brought before the court, and returned to their room, returned a verdict guilty of murder in the first degree, founded on the last 3 counts of the indictment, March 23rd. The prisoner was sentenced to be taken to the state prison at Thomaston, there to remain in solitary confinement and at hard labor 1 year, and at the expiration of that time, or as soon thereafter as the governor might direct, be hanged by the neck until dead. Dr. Coolidge was not hanged, and there is a mystery as to his end. According to some authorities, he died in prison, but there is very strong evidence that he made his escape with the connivance of someone in authority. End of section 89.
Section 90 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. The trial of Raymer C. Wertendyke and James Pike for false imprisonment, and of Robert R. Browne for assault and battery, New York City, 1822. The narrative. Mr. Browne, a stranger in the city, concluded one pleasant autumn evening to attend a service at a nearby church, where he took a seat in the gallery. Perhaps the sermon was long and dull, or the room may have been too warm. For some cause or other he determined to leave, and at the beginning of the final prayer he proceeded to descend. But he was stopped on the stairs by an usher, who told him that it was a rule of the church that no one could go out of the building during divine service except with the express permission of the officials. Mr. Browne persisted and said he would go out if he wished, and two of the officials, Wertendyke and Pike, hearing the noise, came out to the porch and tried to keep him inside. Browne resisted, and the result was a great noise and tumult, which ended in Browne being handed over to the police. All three were afterwards indicted, the two church officials for false imprisonment, and Browne for assault and battery. The judge charged that all three were in the wrong, and the jury, being of the same opinion, acquitted them all. The trial. In the Court of General Sessions, New York City, February 1822. Honorable Richard Riker, Recorder, Jacob B. Taylor, Henry Meade, Alderman. Indictments having been previously found against the three defendants, one against Wertendyke and Pike for false imprisonment, and one against Browne for assault and battery. As the charges grew out of the same circumstances, it was agreed that all three of the defendants should be tried at the same time before the jury. Mr. Maxwell for the people, Mr. Wilson for Browne. The other two defendants appeared for themselves. The evidence. The witnesses stated the facts to be as follows. Wertendyke and Pike were officers of the church at the corner of Christie and Delancey Streets in this city. The authorities of this church had passed a regulation that no person should go out of the church during divine service without their express permission. Browne, who was a stranger in this city, went to worship in this church on the evening of Sunday, the 15th of September, 1821. During the service and at the commencement of the last prayer, Browne arose from his seat in the gallery of the church and walked with some force to the stairs leading to the door of the church. He was stopped on the stairs by Mr. Marine, an usher, and told he could not proceed, that it was against the rules of the church. He, however, persisted in going out. He was stopped at the bottom of the stairs by Wertendyke and Pike, and pushed with great violence against the wall. A considerable noise and tumult arose in and about the door of the church. The two church officials called for the police, who came and at their request took Browne into custody. The recorder to the jury. On the facts stated, we think the conduct of Browne is open to censure. It is the duty of every person attending church, no matter of what denomination, to pay that respect to the place and the people assembled there, as not to disturb or molest them in their worship. Under the free constitution of this country, no man is compelled to go to any particular church, or indeed to any church at all. But if he does go, as it is the duty of every man to go to some church, it is his duty to behave himself while there with decorum and respect. But now as to the rule or regulation passed and attempted to be put into execution by the officers of this church, we think it clearly illegal. It is an infringement upon natural liberty and private right not to be tolerated, nor can it, in law, excuse or protect the officers of the church from the responsibility of any crime they may commit in enforcing such illegal rule. The jury, in accordance with the charge of the court, intimated their disapprobation of the conduct of each of the parties by finding a verdict of not guilty on each of the indictments. End of section 90.
Section 91 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army. Massachusetts, 1778, Part 1. The narrative. One of the earliest great victories of the American Army in the War of the Revolution was the surrender of General Burgoyne and his whole force to General Gates, which occurred at Saratoga on the 17th of October, 1777. Footnote: Gates Horatio, 1728 to 1806, born in Malden, England, early entered a military career, was sent to America and was with Braddock's expedition, made a brigadier general of the Continental Army in 1775, and defeated General Burgoyne at Saratoga in 1777, defeated by Cornwallis in 1780 and removed, acquitted by court-martial, settled on a plantation in Virginia, but removed to New York City in 1790, where he died. End of footnote. A convention was entered into between the two generals, which provided that the British Army should be marched to the port of Boston and should be allowed a free embarkation and passage to Europe, upon condition of not serving again in America. The Army was not to be separated, nor the men from the officers. The officers were to be admitted on parole, and suffered to wear their sidearms. All private property was to be retained, and no baggage was to be searched or molested. The Army immediately took up its march for Boston and was quartered in Cambridge. But the quartering of these soldiers was not regarded with much favor, and the people, who held General Burgoyne and his army in the utmost detestation, did not exert themselves very much for their accommodation. Good housing and lodgings were scarce, and so were food and fuel. The soldiers were soon indignant at what they considered harsh treatment, and took no pains to conceal their contempt for the people whose prisoners they were. The officers forgot the relation in which they stood to their captors, and indulged in haughtiness and arrogance of manner, both unbecoming and annoying. But the American officers had been strictly enjoined to be attentive to the conduct of the prisoners, and to report any insults offered to the independence of the states or the proceedings of Congress. The offender was to be immediately arrested, and if a prompt and full apology was not made, he was to be confined to the guardhouse for a time proportioned to the magnitude of his indiscretion. The prisoners, however, paid no further respect to the rules and regulations of their captors than they were compelled to do by external force. They often stole out of camp and not infrequently committed depredations on the neighboring farms. Highway robberies were not uncommon, and in one instance at least, an aggravated murder was committed. Passes were constantly counterfeited, and officers lent their sidearms or suffered favored soldiers to take them, in order to deceive the sentries after dark. When this artifice was finally discovered, the prisoners who had a right to wear them were often stopped by the guards, and hence there arose complaints without number of the insolence of the American sentinels. Colonel Henley, the American officer in immediate command at Cambridge, was a brave man and a good officer, but of a somewhat irritable and impetuous disposition, coming into frequent personal collisions with the prisoners, and sometimes being pressed beyond endurance by the outrageous insolence of the soldiers. He adopted a course of punishment which was severe, but it should be remembered that he was constantly placed in a trying situation when the most decisive and energetic action was necessary. On January 8, 1778, a report was made to the commanding officer that, in the night before, a British soldier had thrown a stone at a sentry, which had knocked him down, deprived him of reason, and nearly killed him. Search was immediately made for the offender in the sentry's musket, which had been taken off. The prisoners resisted the search and, being armed with clubs and stones, prepared to attack the guard. They were charged, however, with clubbed firelocks, driven from barrack to barrack, and 30 of their number taken prisoners, who were ordered to be transferred to the guardship. Meanwhile, the British soldiers again assembled and were ordered to disperse. They in effect refused to obey and pressed upon the guard, loading the Americans with the most insolent abuse. They also succeeded in rescuing one man when decisive measures became necessary. Colonel Henley accordingly rushed upon the crowd with fixed bayonets, and himself pricked a British soldier with his sword. As soon as General Burgoyne heard of this, he addressed a letter to General Heath, the American commander, in which he demanded the release of the prisoners who had been transferred to the guardship, together with the satisfactory apology, and concluded in the following terms: insults and provocations, at which the most placid dispositions would revolt, are daily given to the officers and soldiers of this army. Regular, decent complaints are received by your officers, sometimes with haughtiness, sometimes with derision, but always without redress. These evils flow, sir, from the general tenor of language and conduct held by Colonel Henley, which encourages his inferiors, and seems calculated to excite the most bloody purposes. For want of sufficient information, and not bringing myself to believe it possible that facts as related by common report could be true, I have hitherto declined taking public notice of this man, but upon positive grounds, I now and hereby formally accuse Colonel Henley of behavior heinously criminal as an officer, and unbecoming a man, of the most indecent, violent, vindictive severity against an armed man, and of intentional murder. I demand prompt and satisfactory justice, and will not doubt your readiness to give it. Whenever you will inform me that a proper tribunal is appointed, I will take care that undeniable evidence shall be produced to support these charges. General Heath at once ordered a court of inquiry to investigate the grounds of the complaint of General Burgoyne, and the report was that it would be most for the honor of Colonel Henley, as well as for the satisfaction of all interested, that the judgment of court-martial should be taken on his conduct during his command at Cambridge. Accordingly, a special court-martial was ordered to sit at the courthouse in Cambridge for the trial of Colonel David Henley, late commanding officer of that post, accused by Lieutenant General Burgoyne of a general tenor of language and conduct heinously criminal as an officer, and unbecoming a man, of the most indecent, violent, vindictive severity against unarmed men and of intentional murder. The court-martial convened in the courthouse at Cambridge on January 20th, 1877, and lasted 5 days. Both General Burgoyne and Colonel Henley appeared in person. The charges were certainly not proved, and the American commander was honorably acquitted. The result was received with great enthusiasm by the Continental Army, and was just as greatly complained of by the British officers and men. The trial. Footnote. Bibliography. Chandler's American Criminal Trials, C1, American State Trials 116. End of footnote. Before a military commission held at Cambridge, Massachusetts, January 1779. Brigadier General John Glover, President. Footnote. Glover John, 1732 to 1797, born Salem, Massachusetts, a sailing master and fisherman. He recruited a regiment and rendered such service to the Patriot Army that in 1777 he was made Brigadier General. He aided in the defeat of Burgoyne at Saratoga and transported to Cambridge the army that surrendered there. Was a member of the court-martial that tried and condemned Major Andre. The other members of the court-martial were Colonels Wesson, M. Jackson, Lee, H. Jackson, Lieutenant Colonels Coleman, Bedlam, Poppin, Major Curtis, Captains Randall, Langdon, Sewell, and Hastings. Lieutenant Colonel William Tudor was Judge Advocate. End of footnote. January 20th. The court-martial ordered by General Heath on the complaint of General Burgoyne assembled today at the courthouse at Cambridge. Footnote. Heath William, 1737 to 1814. Born Roxbury, Massachusetts. Brigadier General, Continental Army, 1775. Major General, 1776. Member, Massachusetts Constitutional Convention. State Senate, 1791. Probate Judge, 1793. Lieutenant Governor, 1806. End of footnote. Lieutenant Colonel William Tudor, Judge Advocate. Footnote. Tudor William, 1755 to 1819. Born Boston, Massachusetts. Graduated Harvard, 1769. Admitted to the bar, 1772. Colonel and Judge Advocate General, Continental Army, 1775 to 1778. After the Revolution, practiced law and rose to eminence in his profession. Member of the Massachusetts House and Senate. Secretary of State, 1809. Vice President, Society of the Cincinnati, and a founder of the Massachusetts Historical Society. In London, he was once presented at court. On the mention of his name, the king exclaimed, "Tudor, what, one of us?" The interview continued so long that the lord-in-waiting, growing impatient, said, "His Majesty seems to be so deeply engaged with his cousin that he forgets what a number of persons are in waiting to be presented." End of footnote. Lieutenant General Burgoyne appeared in person. Footnote. Burgoyne John, 1722 to 1792. Born in England and early entered the army. Captain and Lieutenant Colonel, 1758. Member of Parliament, 1761. General in Portugal, 1762. Appointed head of the British Army to subdue the American colonies by way of Canada in 1777, but was defeated and surrendered to General Gates at Saratoga. On his return home to England, he was coldly received by the ministry and was neglected by the court, his surrender at Saratoga being charged as an act of cowardice. Upon his repeated and earnest solicitation, an inquiry was instituted by Parliament into his conduct on the expedition. It was, however, broken off by the prorogation of Parliament, and never was resumed. After his return, he again became a member of the House of Commons, where he annoyed the ministers by the ability and zeal of his opposition, and they ordered him back to America. He refused to obey, and resigned his commission. In his later days, he engaged in literary and dramatic work, and wrote 3 dramas of considerable merit. End of footnote. Colonel Henley appeared before the court, and the following charge was exhibited against him. Lieutenant General Burgoyne accuses Colonel Henley of a general tenor of language and conduct heinously criminal as an officer and unbecoming a man, of the most indecent, violent, vindictive severity against unarmed men, and of intentional murder. Footnote: Henley David. Colonel Henley was a native of Charlestown, Massachusetts, and was bred to a mercantile calling. At the commencement of the Revolution, he resided in Virginia, and was personally known to General Washington. After his trial, he left the command in Cambridge, and before the end of the war, he retired from the army and went into business with the father of Harrison Gray Otis. End of footnote. Colonel Henley answered that he was not guilty. General Burgoyne: I noticed a distinction between the charges stated in my letter and General Heath's order. In the letter, the general tenor of Colonel Henley's language and conduct, encouraging his inferiors and seemingly calculated to excite them to bloody purposes, was only stated as a matter of suspicious belief. Reasoning upon this principle, it was more candid to suppose one instigator of such evils than a general voluntary bad disposition among the American troops. The direct matter of charge which I pledged myself formally and officially to support was contained in the words, behavior criminal as an officer and unbecoming a man, of the most indecent, violent, vindictive severity against unarmed men, and of intentional murder. General Burgoyne: I make this observation as a security against any censure of inconsistency on my part, for not going at large into matters of inferior moment, as to the general tenor of language and conduct of Colonel Henley, where I shall confine my evidence to transactions of the 19th of December and the 8th of January, except in cases where the behavior of Colonel Henley at other times served to elucidate the principles and designs upon which he acted upon those particular days. With this observation as to the distinction in the charge, Mr. President and gentlemen of the court, I present myself as prosecutor before you in charges of a heinous nature against Colonel Henley, and before I proceed to adduce the evidence in support of them, I think it a duty to my station and a part of propriety towards the court to declare the principles upon which I act. If the reports in my hand, and which will presently be brought to test upon oath, do not deceive me, public faith has been shaken, wanton barbarities have been committed, and a general massacre of the troops under my care apparently threatened. In objects of this magnitude, where not only the rights of a single nation, but the interests of human nature are concerned, the conduct of the prosecution falls naturally, however disagreeable the office and unequal the talents of the person, to him who has the supreme trust upon the spot. A second inducement to appear here is that of private honor. I have undertaken to accuse Colonel Henley in a degree that ought to affect the feelings of a soldier nearer than life. It is fit I stand forth in person to maintain my accusation, and if it fails in point of proof, to make him the fullest atonement in my power. I acknowledge a third impulsion upon my mind, equally irresistible: gratitude, esteem, and affection to that meritorious, respectable part of my country, the brave and honest British soldier, a private man defenseless because unarmed, ignorant of your laws, unqualified to make good his cause in a court of justice, and who has not to look for redress of injury to his own officers. I confess I am too selfish to resign to my brother officers the pride and gratification of standing in the front for the defense of men, faithful comrades of honor and misfortune, who have fought bravely under my orders, who have bled in my presence, and who are now exposed to oppression and persecution by the abuse of a treaty signed by my hand. Thus much I thought proper to premise, lest any man should suppose me actuated by so mean and paltry a motive as vindictive personal resentment against a gentleman, two of whom, before these transactions, I could know no harm, and towards whom, if I had any prejudice, I seriously declare it was, from his general deportment, a prejudice of favor. Personal resentment? No, gentlemen, I stand upon broader and firmer ground, the ground of natural rights, personal protection and public honor, and I appeal to the great principles and landmarks by which human societies hold and are directed, and which, whether in situations of amity or hostility, are esteemed equally sacred by the universal concurrence of civilized man. And this leads me to a momentary reflection upon the order under which you sit, originating from the report of the Court of Inquiry. It states that the court, after mature consideration, are of opinion that from the evidence offered on the side of General Burgoyne against Colonel Henley, it would be most for the honor of Colonel Henley, as well as for the satisfaction of all interested, that the judgment of a court-martial should be taken on his conduct during his command at Cambridge, the general approving the opinion of the court orders, etc. I confess I expected General Heath would have joined issue with the prosecutor in this instance and placed the court-martial upon a more enlarged basis than the honor of an individual, however respectable he may be, or the satisfaction of the complainants. But be it as it may, my purpose is answered. A court-martial is obtained. The members are sworn, and they are bound to decide. I know you will feel with me the difference between this and common courts. Such a state of the minutes as would suffice for your internal conviction after hearing the evidence, or as would be merely explanatory to the person who is to confirm the sentence, will not be thought sufficient here. You well know the whole of this matter will be published, translated, considered, and commented upon by every nation in the world. Not only reality, but perspicuity of justice must appear upon the face of the proceedings. You are trustees for the honor of an infant state, and therefore evasion, subterfuge, and lawcraft, were any man hardy enough to offer such at your tribunal, would be of no avail. Nay, were it possible any member could be warped unintentionally by personal favor or prejudice of civil contest. Good minds are sometimes prone to such illusions. Yet here a moment's reflection upon the reputation of his country would retrieve his reason, and what his prejudice would incline him to adopt, policy would prompt him to reject. Upon the full confidence, therefore, of the necessary as well as willing justice of the court, I shall proceed to call the evidence. I have neither inclination nor power to heighten the facts by a previous narrative. Let them strike the view as truth shall show them, in all the simplicity of their horrors, a monstrous spectacle, from which the mind and eye will turn aside with detestation. End of section 91. Section 92 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army. Massachusetts, 1778, Part 2. The evidence for the charges. Corporal Buchanan was present at the barracks on Prospect Hill on December 1st. Colonel Henley ordered a number of the British soldiers who were prisoners out of the guardhouse. He asked Corporal Reeves what he was confined for. Reeves said that he had affronted one of the provincial officers, not knowing him to be an officer, and he was sorry for it. Colonel Henley replied, "Sir, if you had served me so, I would have run you through the body, and I believe you to be a great rascal." Reeves answered, "Sir, I am no rascal, but a good soldier, and my officers know it." Colonel Henley demanded silence. Reeves repeated, "I am no rascal, but a good soldier, and I hope soon to be under the command of General Howe, to carry arms and to fight for my king and country." Colonel Henley said, Damn your king and country. When you had arms, you were willing to lay them down. Reeves said he was not willing to lay them down. Colonel Henley again ordered silence. Reeves not obeying, but repeating the same words. Colonel Henley ordered one of the guard to run him through the body. The man not obeying him, Colonel Henley dismounted from his horse, and seizing a firelock with a fixed bayonet from one of the guard, stabbed Reeves in the left breast. While the bayonet was at Reeves' breast, Colonel Henley told him if he said another word he would have it through his body. Reeves said he did not care. He would stand for his king and country till he died. Colonel Henley made another push at him, when I threw up my hand and turned the bayonet over Reeves' shoulder. Told Colonel Henley the man was a prisoner, and said, "Don't take his life, as he is now in your custody. You can't take other means with him." Colonel Henley returned the firelock to the man of the guard he took it from, and then ordered Reeves and myself into the guard room, and dismissed the rest of the prisoners. General Burgoyne. When Colonel Henley made the second pass at Reeves, where would it have struck him had you not thrown the bayonet up with your hand? Much about the same place in the left breast. When Colonel Henley demanded silence, did he direct himself particularly to Reeves? I can't tell, as there were 10 or a dozen prisoners who were making their excuses together. Was there not much noise in what sounds made by the prisoners? It was excusing themselves to one another, so that Colonel Henley might hear them, that they had been confined there for some nights, and they should take care not to come there again. Was there any muttering or grumbling or insolent looks directed to Colonel Henley? No, but quite the reverse. The men seemed pleased at being released. Alexander Thompson belonged to the 29th Regiment, was at the barracks on Prospect Hill on December 19th. Colonel Henley ordered the prisoners out of the guardhouse, of whom I was one. The prisoner was drawn up before the guardroom window, the guard in their front. Colonel Henley, from a paper, read the crimes at the right of the line of the prisoners, and said, "Now, soldiers, I am come to release you, and hope you will behave better for the future." He told Corporal Reeves he was confined for abusing an officer of the Continental Service, and asked him what was the reason of his abuse. Reeves replied he did not know the reason of the abuse, as he was in liquor at the time, but said he was very sorry for it, not knowing him to be an officer. Colonel Henley then said, "Had it been me, I would have certainly run you through the body. I believe you to be a rascal." Reeves said he was no rascal, but was a good soldier, and his officers knew it. Colonel Henley demanded silence, and Reeves again said that he was a good soldier and hoped in a short time to fight under General Howe for his king and country. Colonel Henley then said, "Damn your king and country. When you had arms, you were willing to lay them down." Corporal Reeves made answer that he was not willing to lay them down, and had he then arms, he would do his utmost to fight for his king and country. Colonel Henley then ordered one of his guards to run the rascal through. The man not obeying, he dismounted, seized a firelock with a fixed bayonet from one of the guard, extended his arm above his head, with his hand on the butt of the firelock, and made a pass at Corporal Reeves, and pricked him near the nipple of the left breast. He then drew back the firelock, and made another pass at him. I seized hold of the socket of the bayonet and begged Colonel Henley not to take his life, that he might use other means of satisfaction, and begged he would send him into the guardroom again. Colonel Henley then ordered Reeves into the guardroom. The guard committed him, and Colonel Henley went on to speak to the rest of the prisoners. Reeves put his head out of the guardhouse window and said something, but I do not know what. Colonel Henley then released the rest of the prisoners except Buchanan, who was ordered into the guardhouse. The President. Was there nothing said by Reeves between the first and second pass of Colonel Henley? No. Did not Colonel Henley frequently command silence before he stabbed Reeves? He did more than once or twice. Did not Colonel Henley direct himself to Reeves when he demanded silence? He looked first at Reeves and then along the line of the prisoners. Was not Reeves more talkative than any of the other prisoners? He was. Was anything said about King Hancock? I heard nothing. Corporal Buchanan recalled. After Reeves was returned to the guardroom and the other prisoners dismissed, Reeves said to me, "This is a poor pass I am come to be taken out of the guardhouse and stabbed, and my king and country damned. Damn King Hancock and the Congress." Colonel Henley might have heard it. Dr. Bowden, surgeon of the 9th Regiment, saw Corporal Reeves a few hours after he was wounded. The wound appeared to be made by a bayonet. It penetrated the breast a little above the left nipple. It was not so bad as to require immediate dressing. It was slight. It did not penetrate deep enough to be of any consequence. It might have drawn a drop or two of blood. General Burgoyne. What further depth would have put his life in danger? An inch farther might have rendered the wound hazardous. Was the direction of the wound towards the heart or a mortal part? It was not towards the heart, but towards a mortal part. Page. Am a soldier of the 24th Regiment. Was at the barracks on Prospect Hill on January 8th. About 11 in the morning saw a guard of Continental soldiers coming up from Winter Hill. When they came near the British guardhouse, a number of us were standing to see them march by. Happened to tread on one of my comrade's toes, and he cried out, "God damn my soul!" When a sergeant, as I took him to be as he was out of the ranks, turned about, stepped back 2 or 3 paces and stabbed him in the right breast, and drew out his bayonet from the man's breast and said to the man, "Damn you, you rascal! Do you damn me?" The soldier made answer, "No." I said that he did not speak to him. He then made another push at him and pricked him the second time, and then clubbed his firelock and cut him on his right temple. A provincial officer came from the rear of the party and damned us for rascals, and told us we all deserved it. Did not see Colonel Henley near during this. 50 or 60 British soldiers were together when the party passed them. General Burgoyne. What number did the provincial guard consist of? I guess about 150. Did you see any insult by word or gesture passed from the British soldiers toward the guard? I did not. Did you hear any provincial officer or soldier complain of any affront offered? I did not, except what passed as before related. The President. Did the British soldiers give the party full room to march in the same open order after they came up to them as before? There was full room where I stood for the party to pass. Walker, surgeon's mate of the 24th Regiment. On January 8th, about 11, I dressed a British soldier who had just before been wounded. His name was Traggett. There were 2 orifices just above the right breast, which the man told me had been done by 2 different stabs of the bayonet. From the free communication of the 2 orifices, should have thought it had been only one wound. The wound was not dangerous. Have dressed it several times since, and at present it is in a fair way of a cure. Saw no other wound, nor any marks of beating about the man. Am of opinion from the nature of the wound, it was done by one push. The man did not complain of any wound. Major Foster, belonged to the 21st Regiment, was present on the occasion referred to. Neither saw nor heard any provocation on the part of the British soldiers towards the Continental Guard. When the rear of the guard came near the British guard room, noticed a scuffle. The guard passed on, and I found Traggett, a British soldier, was wounded. I ordered the men to disperse, and they did so immediately. Corporal Kidley saw a wound inflicted on another soldier on the same occasion. Colonel Henley came up with a party of American soldiers, and after forming them into 2 columns, ordered them to load. He told them that the first man who rescued a prisoner out of his hands, he would blow his brains out. He then ordered the British soldiers to leave the parade immediately. They moved off, but Colonel Henley, finding that they did not move, as fast as he expected, rushed forward and stabbed Corporal Hadley. He followed another soldier, threatening to run him through if he did not go off the parade. The wound of Hadley was not severe, and he was only confined by it a short time. Colonel Anstruther am the British officer in command. I called on Colonel Henley, who informed me that the British soldiers had behaved so badly that morning that he was obliged to run one of them through the body, and that some others had been hurt by his men's bayonets. Colonel Lind belonged to the 20th Regiment about 22nd December. Being field officer of the week, I was going upon Prospect Hill in the forenoon with Captain Banks of the same regiment. Saw 3 women coming down the hill, one of which run past a Continental sentry, who called upon her to stop and immediately fired his piece before she had time to turn round. The ball from the noise passed between the woman and myself and near me. Ordered the woman to go back, and went up to the sentry and asked him if he was not ashamed to fire upon a helpless woman. He replied he had orders for so doing. Went to his sergeant's guard, which was just by, told the sergeant what had happened, and desired him to confine the sentry, that the affair might be inquired into. He told me he would not confine him, that they had orders to fire upon all British soldiers and women who attempted to pass the sentries. Observed a number of British soldiers were collecting, who were murmuring and clamoring at the time, but fear of the consequences desired them immediately to disperse and go to their barracks, and promised them my endeavor to get them redressed. Went towards the Maine or Captain's Garden in my way, was stopped by a provincial sentry, who charged his bayonet upon me, with the muzzle pointing at my breast. Told him I only wanted to speak to the captain of the guard, and did not want to go further, and begged he would call him, and remove the muzzle of his gun from my breast. He said he would keep the muzzle there and bid me keep off, and then called the sergeant of the guard, who immediately came up, desired him to order the sentry to remove his firelock, as I was an officer, and commanded in the barracks, and wanted to speak to the captain of the guard upon business. The sergeant told the man to take away his gun, telling me he was a young soldier and did not know better. The captain of the guard came up soon after, and I pulled my hat off, which he took no notice of. Told him of the sentry's firing on the woman, and begged the sentry might be confined till the affair should be inquired into. He told me that he would not, and that the sentries had particular orders to fire on all women who attempted to pass the sentries, as well as soldiers. I said it must be some mistake. He replied it was none of his business. They were his orders, and I must seek redress somewhere else, and we parted. From the position of the sentry at the time he fired, passengers on the road were exposed to the shot. No report of this transaction was made to Colonel Henley that I know of. John Fleming, am sergeant of the 47th Regiment. About 16th was at the door, with the number of the sergeants of the office to apply for passes. Mistook Colonel Henley for Mr. Keith, the Deputy Adjutant General, and saluting him, was just going to address him when Colonel Henley extended his arm, with his fist clenched, and exclaimed, "You rascal, I'll make damnation fly out of you, and I will myself one of these nights go the rounds, and if I hear the least word or noise in your barrack, I'll pour shot amongst you, and make flames of hell jump out of you, and turn your barracks inside out. Ye are all a parcel of rascals." He said if he was a sentry and a British soldier looked sulky at him, he would blow his brains out. I asked whether anything was amiss. He said there was, for that the last night one of his sentries had been knocked down by some of our people. He moderated his passion, and a very few words passed afterwards. General Burgoyne asked to address the court upon the facts as proved. The judge advocate interposed an objection. He contended that in courts martial there was no prosecutor but the judge advocate. There had been instances of counsel being allowed a prisoner, but not against him. Still, if Colonel Henley had no objection, and the court conceded it as an indulgence, he should acquiesce. General Burgoyne expressed surprise at the judge advocate's exception being made so late in the case. He thought it more particularly extraordinary, as the general had not only stated his idea of the mode of proceeding at the first, in which the judge advocate had acquiesced, but at the last meeting it had been fully discussed in open court between them, and the judge advocate had agreed to his right, both of applying the evidence upon the charge and also of replying to the defense, provided the judge advocate at the closing of the whole. He averred that, had the court declared against the claim in the beginning, or could he have expected such objection, he should have examined the witnesses in a very different manner, in order to bring several matters more fully and pointedly before the court than he thought necessary to do upon the supposition of a future occasion, to explain the reasons of his questions, and by deduction and inference to make the application. He nevertheless proposed that the principle upon which he spoke should lie dormant to avoid trouble to the court, that he had his own opinion upon the right. The judge advocate might retain his upon the indulgence, and provided nothing concerning the matter was entered upon the proceedings, he should make use of the power without further question. Colonel Henley: Mr. President and gentlemen of the court, I have no objection to General Burgoyne's making use of all the rhetoric in his power against me. I stand on such firm ground, I can safely trust my reputation in your hands against every effort of my prosecutor to ruin me. The court, after consultation, informed General Burgoyne that he might proceed. General Burgoyne: Mr. President and gentlemen of the court, it being now admitted that in closing the evidence I may offer such arguments as to me shall seem proper in support of the charge, and reserving to myself a claim of replying to the defense, I shall enter upon the first part of the very painful, though by no means difficult undertaking. Painful, because I cannot pursue the offender without setting that offender in points of view, at which every benignant mind might shudder. Easy in every other respect is the task, because I will venture to pronounce the evidence, when arranged and adjusted, will amount to such a mass of proof as cannot be overthrown, and will authorize and call for the strongest terms I can use in my demand of public justice. And, gentlemen, let me be permitted to assume to myself applause rather than blame that the evidence has not been laid before you in a regular series. The reason was that though assured by the reports made to me that the evidence would produce conviction upon the whole, I was ignorant how the testimony of the particular witnesses would apply, and point to the progression of the charges, because I had no previous intercourse with them. I declare upon my solemn word and honor that I had no concern of communication, directly or indirectly, with any non-commissioned officer or soldier who has appeared at your bar, one only excepted, namely Sergeant Fleming of the 47th Regiment, who has deposed to the salutation Colonel Henley gave him and his comrades at the Adjutant General's office. The whole matter appeared so very improbable that I not only sent for the sergeant to warn him of the sacredness of an oath and the crime of intemperate zeal that led to bearing false witness, but also I thought it is my duty to inquire minutely into his character. I found the man firm in uniform in asserting his facts, and I found his officers unanimous in supporting the credit of his veracity. In every other circumstance, I adhered religiously to the determination I had taken of secluding myself from the witnesses, not only to guard my character in this region of suspicion and aspersion against the supposition of unfair practices. I besides had a scruple of trusting my own mind with too hasty prepossessions in a cause where, with the solemn matter of a public nature, is involved the fate of a gentleman, high in his military station, and to judge by the apparent signs of good wishes on this day, high in popular esteem. Thus unprejudiced I came into court. I scorned to take the slighter matters that might be comprehended in the general words of the charge, such as personal incivility to the officers, expressions and actions of peevishness, haughtiness, and disgust. I mean not to press that they existed, or if they did, I am desirous that they should pass as faults of temper and deficiencies of manners, incident to man's nature, education, and habitual course of life. And I shall confine my comments, as it is my duty to do, to the testimonies of your minutes and the circumstances relating to them. Without departing from this principle, it will be necessary to take a general view of the state of things previous to the date of the grievances complained of. We arrived at Cambridge, passengers through your country, under the sanction of a truce. In whatever capacity we had been found in a foreign, and as you intend, an independent state, we were entitled to a personal protection by the general and most sacred laws of custom and reason. But when, to the promulgated law of civilization, are added the unwritten principles, or written only upon the hearts of generous people, honor, respect of the brave, the hospitable wishes that usually press to the relief of the unfortunate, the stranger, and the defenseless man in your power, how will our claims multiply upon the mind? Sanguine imaginations conceived yet further motives for kindness. There were among us men so vain as to believe that, notwithstanding the separation between us, the different duties we now maintained, the prejudices of political zeal, and the animosity of civil war, yet still the conflict over, it might be remembered we once were brothers, and the more especially as it was impossible, by the Convention of Saratoga, that the generality of us should ever oppose America in arms again. We were led into these delusive hopes by the very honorable treatment shown us by General Gates, by that we received from you, Mr. President, when you conducted us upon the march, and by that we afterwards found from the worthy member of the court near you, who had the immediate command in this district upon our arrival, and to whom, most happily for us, the command is now again devolved. The first symptom we discovered of any uncandid design was the mode established for correcting errors and disturbances in the troops of convention. Men were taken up, imprisoned, and otherwise punished by the American troops, without any prior reference to their own officers. I very well know with how much slight and severe derision my sentiments have been treated on this subject, but I still insist that after taking up men for faults, to have applied to the officers of the convention troops, in the first instance, for their punishment, would have been consonant to every principle of decorum and good policy, not meaning to deny that upon any proof of partiality or connivance, or undue lenity, it then became a proper and indispensable duty of General Heath to take the distribution of justice into his own hands. Footnote: when the British troops first arrived at Cambridge, the officers wished to have the sole jurisdiction of all offenses committed by their own soldiers. The American commander admitted that the British officers might command and punish for the purpose of internal order and obedience, but the exercise of his own command and the enforcement of his own orders, when necessary, was a jurisdiction which the British officers must not expect to exercise. Heath's Memoirs, 136. End of footnote. The contrary maxim having been established, let us examine in point of time, though the last in the proceedings, that burst of independency, scurrility, and impiety from Colonel Henley to the quartermaster sergeants of the Adjutant General's office. It is not without difficulty I can frame my mouth to read the words as they were delivered upon oath by that very respectable witness, Sergeant Fleming. You rascals, etc. I'll make damnation fly out of you, and I will myself, one of these nights, go the rounds, and if I hear the least word or noise in your barracks, I'll pour shot amongst you, and make flames of hell jump out of you, and turn your barracks inside out. The court will remember that when this evidence was given, it rather excited laughter in some part of the audience than any serious condemnation. This day it seems to make a very different impression. The minds of all around follow me while I contend. That expression so wild, so unfit, so unprecedented, from the mouth of a gentleman, argue the most horrid passions boiling in the breast, the very enthusiasm of rage and malice. I defy any man to divest himself of that idea. It will attend the mind through the whole course of the proceedings, and cast a shocking glare over every subsequent transaction of forethought, intention, and bloody resolution. It is very material to observe that this demonstration of Colonel Henley's mind was on or about the 16th of December, and it was no longer then, till the 19th, before he confirmed by an overt act the principles he had professed. The stabbing of Corporal Reeves is proved by the evidence of Corporal Buchanan, Alexander Thompson, and Robert Steele. I shall quote indiscriminately from the testimony of these witnesses, because though one may recollect a few short passages of words more than another, there is not a shadow of contradiction, and I am confident there never was an instance where truth was laid before a court by united evidence more perspicuously. It has been sworn that on the morning of the 19th of December, Colonel Henley went to the barracks on Prospect Hill to release some British soldiers who were prisoners, that having paraded them, he read over their crimes, and coming to Reeves, told him he was confined for insulting a provincial officer. Reeves made answer he was sorry for it, that he was in liquor, and would not have acted so had he known him to have been an officer. I pause here to apply to the feelings of the court whether a more decent, proper, and satisfactory excuse could have been conceived. What did it draw from the colonel? Had it been me, you served so. I would have run you through the body, you rascal. Continue the comparison between the language of the colonel and the corporal. Sir, I am no rascal, but a good soldier, and my officers know it, and I hope soon to be with General Howe, and fight for my king and country. What did this produce from the colonel? Damn your king and country, and an order to the guard to run him through the body. Not a hand nor heart could be found for the butchery. The colonel, enraged at the virtuous disobedience of his men, leaps from his horse, seizes a firelock with a fixed bayonet, and strikes at the man's heart. I call upon the gentleman of a learned profession near me to inform the court, when he sums up the evidence at the close of the trial, whether this act would not constitute malice prepense in law. I mean that admitting, for the sake of argument, that there had been such provocation given as would have justified a man having an offensive weapon to make use of it instantly, which would have been only manslaughter, whether the intermediate act of dismounting a horse and taking a firelock from the other, implying time for recollection, would not have constituted the act of willful murder, had the man died. Consider now, gentlemen, what followed. The brave corporal, in the instant expectation that his words would cost him his life, persevered. I don't care. I will stand by my king and my country till I die. The action would have charmed a brave man. It would have been a spell upon his arm, and kept the stroke suspended beyond the power of witchcraft. What effect had it upon the colonel? To provoke a second stab, which was only diverted by the intervention of the man next him, who caught hold of the bayonet and threw it up. Gentlemen, when I say the perseverance of the corporal ought rather to have pleased than provoked, I speak not vaguely or romantically. I feel conscious proof of the truth. And when I consider the actions of a Washington, when I meet in the field a Gates, an Arnold, a General Glover, and see them bravely facing death in support of their principles, though I would shed my last blood upon a different conviction, I cannot withhold from the enemy the respect due to the soldier, and the immediate conflict over, he robs me of my anger and seizes my goodwill. Gentlemen, in the different parts of the examination upon this fact, many questions have been asked by the prisoner, by the judge advocate, and by the court, respecting the appearance of the prisoner's temper. Was he not in a mild mood? Did he not seem good-humored? Mild murder, good-humored murder, are phrases, I fancy, will not convey any clear meaning till men change their ideas of that crime. We hear, it is true, sometimes as a sort of proverb to mark the utmost malignity and treachery of a man smiling in your face while he cuts your throat. But I believe such smiles were never produced as excuses or extenuation of guilt. These questions, therefore, as I conceive, can have no tendency but to insinuate that Colonel Henley's passion was entirely raised by the immediate provocation he received. I am ready to join issue upon this argument, and if the gentleman will rest his cause upon it, I will relinquish the proof established of Reeves' decency and consistency, and give him latitude for all the provocation he can suppose, short of personal assault and the necessity of self-defense, which I am sure will not be pretended. Transpose, if he pleases, the time when Reeves is proved to have talked about King Hancock, and bring it back to the instant where it was attempted to be introduced as a substantial matter of provocation. He shall add insolence of gesture to abusive terms, and under all these fictitious circumstances, I will take the judgment of the court or the Colonel Henley, with full powers to imprison and to punish by regular, decent legal proceeding, as a shadow of justification for making himself, in his own person, party, judge, and executioner. On the 19th of December, the hands of Colonel Henley were imbrued in blood, till the 5th of January. But it evidently appears upon your proceedings that the influence of his example and the encouragement of his precepts failed not to operate. As the first proof of it, I request the attention of the court to the testimony of Colonel Lind concerning the position of the sentry, which was such as must necessarily affect every passenger upon the public road, whenever he fired, and at the same time with a readiness to do mischief so marked that he took women for his objects, and would not give them time to turn round. He had orders so to do. Let the behavior of the next sentry to whom Colonel Lind applied, concerning the ungentlemanlike behavior of the officer, with his confirmation of the whole proceeding, being according to order, he combined and compared, and it must universally strike common sense that these were several parts of one determined plan to diffuse the seeds of discord and fury, in order afterwards to countenance a general havoc. But, it may be said, the orders under which the Continental troops acted were not those of Colonel Henley, but of a superior. Will that be pleaded? Was the position of the sentries to kill or wound 3 or 4 passengers at a shot? The firing upon women? The refusal of redress to Colonel Lind, with all the indecent manner and language attending? Will these circumstances be alleged to have proceeded from superior orders? If so, the excuse indeed becomes more alarming to us. It is not my part at this time to drop a consideration that would lead far on that subject. I shall only remark how little the excuse would benefit Colonel Henley, who would still remain a cruel agent of, I will use no improper terms, I will only say, a cruel agent of too hasty principles. Colonel Henley has asked whether complaints were made to him of the transactions of the 22nd. I believe they were not, but I dare say he will recollect the reason. Other grievances of the most atrocious nature, abuse of officers and assaults upon their lives, were preparing to be laid before General Heath. They were in number and in time to have filled up a much longer interval than between the 19th of December and the 8th of January, and not brought before this court, because I understood it to be the intention of General Heath they should be separately inquired into. Enough has appeared to show how the system of persecution was preserved, and I come now to the transaction of the 8th of January. Upon the general view of that black day, I am at a loss where first to carry your observation. The field was extensive, the scenes separate and successive, but evidently guided by one uniform design. In one place, a party on the march is stabbing and knocking out the brains of innocent spectators. At another, men, under pretense of a prisoner's escape, are glutting the same bloody purposes upon men not pretended to be concerned. In a third, Colonel Henley in person. The British officers at the same time being denied admittance, is running men through the body with his sword. The first of these complicated horrors in point of time was the attack first with the bayonet, and afterwards with the butt end of the firelock. I will read the evidence without a comment, and I have only now to remark it is rather a prepossession in favor of the Continental troops to suppose that such malicious treatment could proceed from a general sentiment. No body of people is so barbarous, unless instigated, and now is the time to call upon the learned gentleman near me, for another duty of his office, to expound to the court the principles of law, respecting accessories and accomplices, and to say whether a man by order, advice, example, or any other encouragement, influencing another to do a mischievous act, is not particeps criminis at 100 miles distance, as much as if present on the spot. The stabbing of Wilson follows the course of the evidence, and it appears as little comment is necessary upon this as upon the former action, further than to remark that in this case Colonel Henley is found to be accessory, not upon circumstantial, presumptive, and argumentative, but upon positive proof, for it is sworn this action was done in his sight. Then he made no attempt to prevent it, and though it be alleged and even admitted that he was at too great a distance, yet is giving no reprimand or check to the soldiers upon seeing the act committed, carries as direct a conviction of approbation and encouragement as if he had given open applause. The last act to mark the thirst of blood is the stabbing of Corporal Hadley, and following winks with threats of the same fate. It would be superfluous to expatiate upon the strength of the proofs, the concurrence of witnesses, that there was no provocation to this deliberation and wantonness of barbarity. The intention is so clear, in my opinion, against the probability of doubt, that I should not touch a moment upon it, were it not that a very grave application was made to the court, by the most respectable authority in it, to consider the nature of the wounds, as matters of the greatest importance, and question upon question was put to the surgeon in every case to find whether they were dangerous or not. Is it possible that any gentleman can mean to measure the degree of the crime by the depth of the wound, and to argue that a man may thrust a weapon into another's breast with impunity, providing he does not touch a mortal part? If this doctrine holds good, you ought to establish schools of anatomy for the education of young officers. The science of dissection should be added to the skill of the fencing master, to train the pupils to that nicety of touch that can feel to a hair's breadth between death and life, a sort of fiddlestick dexterity that can run divisions upon veins and arteries, and stop short in time and tune to the 1,000th part of a second. Really, gentlemen, I am not willingly ludicrous upon this subject, but it is impossible to treat such an argument gravely. I dismiss it to my learned neighbor, with one more injunction to show the court in law, that where a man passes a sword with violence at another's breast, whether the wound is a mere puncture or goes to the hilt, the intentional guilt is the same. I have only one matter further to observe upon the cross-questioning of the witnesses. It has perhaps been wished to insinuate that at the time of these violent proceedings there was cause of apprehension the armed troops might be surrounded and overcome. The troops themselves will hardly thank their friends for that idea. What, shall it be alleged that the militia of America, who, animated by their cause, have been self-taught the use of arms, that body, where every man has supposed himself to be a host, shall such soldiers be apprehensive of danger from half their number of unarmed, mercenary, ministerial slaves, for such I know they think us? No, gentlemen, I reject with you so injurious a supposition. I give credit to the spirit and force of your militia. I do it seriously and upon experience, and it is upon that credit I found this proposition, that it being impossible the officers and soldiers should be induced to acts of violence, by any apprehension of resistance. It follows, by the fairest deduction, that either there was more prevalent malignity than ever appeared before in the human heart, or that the whole proceeded from direction, order, and a systematical plan. Little more, I imagine, need be remarked to apply the evidence to the several distinct terms I have used in the charge. That the whole tenor of Colonel Henley's conduct was heinously criminal, as an officer, will hardly be disputed in a country where the principles of liberty have been so deeply studied. An army is not to be born in a free state, but upon the principle of defense against an outward enemy, or the protection of the laws. The officer who makes himself the arbiter of the law is guilty of the most shameful perversion of moral duty, and his impunity would scarcely be thought a very comfortable presage of the growing liberties of his country. I have also said the colonel's behavior was unbecoming a man. I will not trifle with the time or understanding of the court to enter into definitions upon this term, nor will I shock the ears of the officers, nor even of the unfortunate person upon trial, with so gross a term as the world in general applied to the act of assaulting a woman, a priest, or unarmed man, for they are all exactly in the same predicament. The sword drawn for such a purpose is no longer the badge and distinction of a gentleman. It is degraded with the implements of the assassin and hangman, and contracts a stain that can never be wiped away. Gentlemen, I have now gone through the material parts of the proceedings. Whether the offenses are resolved into vindictive resentment, or more deep design, or both, it must still appear wonderful that a general massacre did not ensue. By the patience and the discipline of the British soldiers, those horrors have been avoided. But whatever the escape may have been upon our part, it is tenfold more material on yours. We might, perhaps, for the struggles of the desperate are hard, but perhaps we might have been sacrificed to the last man. We should thus have paid a soldier's debt, which we have often risked. Our fall would have been revenged, and our memories attended with pity and honor. But for America, the transactions would have remained a foul and indelible blot in the first page of her new history, nor would any series of disavowal and penitence, no ages of rectitude in government, purity in manners, inflexible faith, or the whole catalogue of public virtues, have redeemed her in the opinion of mankind. Now, gentlemen, consider the words of the order under which you sit. Reform the opinion of the Court of Inquiry, and say whether it is the honor of Colonel Henley or the honor of America, by which your minds ought to be impressed when they proceed to judgment in this cause. I close with that consideration, as far as I can impress it upon your breasts. I trust they are replete and pregnant with justice, honor, and duty to your profession, and above all, with that glorious Whig principle, the words of which are become almost a general motto in this country, and the genuine substantial practice of which I shall ever revere in any country, a due sense of the general rights of mankind. I trust you have all these qualities, and in that persuasion I cannot doubt what will be the issue of the cause. The judge advocate declined making any observations on the evidence until the witnesses in behalf of Colonel Henley had been examined. He renewed his objection to General Burgoyne's making any remarks upon the evidence, regarding it as improper and a dangerous precedent. Colonel Henley declined at this time to enter into a detail of his conduct as connected with the charge. He only requested that the witnesses in his behalf might be examined, and if any remarks in his own vindication should seem necessary, he would submit them afterwards. End of section 92. Section 93 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army, Massachusetts, 1778, Part 3. The evidence against the charges. Major Swayze was present with Colonel Henley at the guardhouse on Prospect Hill when he wounded Corporal Reeves, attended him there with the design of inquiring into the offenses of several British soldiers who were confined in the guardhouse. Previous to this, had acquainted Colonel Henley with General Heath's orders, which were to release those prisoners whose crimes were trifling. Those who had insulted any inhabitant and refused making any atonement for the affront were to be sent on board a guardship. When we came to the guardhouse, the prisoners were ordered out and paraded, examined the charges of each, and finding Buchanan and Reeves, who stood together, were confined. Buchanan for insulting and striking an inhabitant, Reeves for insulting an officer. We passed these two over as not subjects of releasement. After learning the other prisoners' offenses, Reeves was called upon to relate how he got into confinement. He mentioned the circumstances and closed his narrative by repeating a low and very abusive expression, which he had made use of to the officer who confined him, on which I told him he was an impertinent rascal, but treating any person with such language. He replied he was no more a rascal than I was, that he was a good soldier. On this I ordered silence and threatened if he did not stop his impertinence, I would lay him over the head with my whip. He kept on his talk, and Colonel Henley dismounted his horse, after bidding the fellow be silent to no purpose, took a firelock with a bayonet from one of the guard, and told Reeves if he said another word he would run him through. Reeves replied he might do it if he pleased. Upon this Colonel Henley made a lunge at him, and pricked him in the breast. Reeves continuing his insolent language, Colonel Henley stepped back and made a motion to cock the firelock, and told him if he was not silent, he would blow his brains out. One of the British soldiers, finding Reeves was not to be silenced, begged of the colonel to return him to the guardhouse. Buchanan and the other British soldiers begged the colonel not to take notice of the affair, for Reeves was drunk. On this Reeves damned them, and said he was not drunk. He was ordered into the guardhouse. Do not remember that much swearing passed, nor can I recollect the words of insolence used by Reeves. After Colonel Henley had pricked him, Reeves said he was a good soldier, and he would fight for his king and country as long as he had breath, and hoped that he should soon be with General Howe, that he might seek revenge. Colonel Henley's intention in making the pass at Reeves was only to silence him, for had the colonel extended his arm, he might have run him through with the bayonet. General Burgoyne, did you hear Colonel Henley order any of the guard to run Reeves through the body before he dismounted from his horse? I did not, but he might have done it. In what position was Colonel Henley when he made the pass? He had his right hand on the butt of the firelock, and the left grasping the stock. Did you hear Reeves apologize to Colonel Henley for insulting the officer? He said he did not know him to be an officer. By what rule do you judge of insolence of language when you do not remember the words? By the manner. Did Reeves throw out any reflections upon America, or the persons concerned in the cause of it? He did not, that I heard. Did you consider Reeves saying he would fight for his king and country as part of the insolence you mentioned? I did not. Colonel Henley, in reply, damned General Howe, or his king and country, and told him nobody blamed him for fighting in the cause he had engaged in. Did you see any resistance made or any mark of disobedience on the part of Reeves to the colonel's orders, except his not being silent? There was no other order given. Reeves made no open resistance. In going down to the guardhouse, did Colonel Henley express satisfaction at having it in his power to release the British prisoners? He did. Silas Wilde, captain in the militia, had command of the guard on 19th December. Colonel Henley and Major Swayze came to the guardhouse and inquired what number of persons I had in custody, and ordered them paraded. They were accordingly drawn up in a single line. Reeves was on the right, and Buchanan next to him. The colonel mildly asked the prisoners why they would get into difficulties. I handed the charges against them to Major Swayze, and as he read over their names and offenses, the colonel spoke to each one upon the subject of his confinement. When he came to Reeves, he observed to him that he was the lad who abused an officer down in town. Reeves did not know him to be an officer at the time. Major Swayze told him that if he had been the officer, he should have taken his satisfaction on the spot. Colonel Henley then told Reeves he was a rascal. Reeves replied, "I am no rascal, but a true Briton, and by God I will stand up for my king and country till I die." The colonel told him that he was a good fellow to stand up for his king and country, that he did not blame him, but he must be silent. Reeves kept on talking. The colonel ordered silence and turned to Buchanan. The major went on to read his crime, and Buchanan was making an excuse for his conduct. Reeves continued talking and swearing, and turned round to Buchanan and said, "Damn you, why don't you stand up for your king and country?" Buchanan desired him to be quiet. Reeves answered, "God damn them all, I'll stand up for my king and country while I have life. If I had my arms, I would soon be with General Howe and be revenged on them." Upon this, Colonel Henley got from his horse and took a gun from one of the guard with a fixed bayonet, and brought it up toward Reeves' breast, and made a push at him and said, "You rascal, if you don't hold your tongue, I will run the bayonet through you." Reeves stepped 1 foot back and said he would stand up for his king and country, and if you have a mind to kill me, you may. The colonel brought up the piece again, and Reeves repeating the same words, the colonel exclaimed, "God damn your king and country. If you do not hold your tongue, I will run you through the body." Buchanan then took hold of the musket, and Colonel Henley bid him keep his distance. Finding Reeves was not to be quieted, I desired the colonel to recommit him, and he was remanded to the guardhouse. After he was in the guardhouse, he looked out of the window and kept talking and swearing, while Colonel Henley was addressing the other prisoners. Supposed Colonel Henley. In the past, he made at Reeves, intended only to silence him. The colonel spake very mildly till Reeves said, "God damn them all." He dismissed the rest of the prisoners with a mild reproof. Colonel Henley did all he could to satisfy the prisoners before he dismissed them. He mildly cautioned them, and told Buchanan he would release him after he had wrote to the inhabitant who had been abused. If Reeves had not stepped back, do not think the bayonet would have gone into his body. General Burgoyne. Is it usual in the American service to silence men by the sword and bayonet? No, it is not. But when the temper is raised, a man will do that which at another time he would not. Did not hear Colonel Henley order any of the guard to run Reeves through the body before he got from his horse. Several witnesses testified as to the occurrence at the guardhouse, that the language and conduct of Reeves was indecent and insulting to Colonel Henley. Reeves was then in confinement for using language to a Continental officer of an indecent character. Colonel Garish belonged to the militia. On the evening of January 7th, a messenger came to me at Winter Hill, where my regiment is posted, and acquainted me that a sentry had been knocked down on his post, and his gun taken from him. In consequence, I ordered the regiment out, and detached 200 men with 2 captains, as a reinforcement to the guard at the French lines on Prospect Hill, with orders to march silently and surround the first row of barracks, where I suppose the gun was carried in. I accompanied the detachment. The party was in 2 divisions, one under Captain Hughes, the other under Captain Kimball. Left the party under Captain Hughes in front of the first row of barracks, and then Captain Kimball, who had mistaken my first orders and got to a wrong situation, to join Captain Hughes, while Captain Kimball marched to make the junction. I was left a little behind in front of the second row of barracks. A British soldier came out and said to me, "Damn you, what do you come here for? We have done you no hurt in these barracks. We have got arms and we will shoot you." Thought the sentry's gun might be in that barrack, and called for a sergeant and a dozen men. They came up. Then the British soldiers came to the door of the barrack and presented a weapon out. I thought it had been a musket, though I afterwards found it had been only a club, and said, "God damn you, we'll shoot you." Ordered my small party to fire upon them, but upon the party's cocking, recalled the order as the British soldiers in the room might not all be guilty, and some of my own men might be endangered, who were in the rear of the barrack. We approached close to the door and found that they were not guns which the soldiers in the rooms had in their hands. One of them, as we approached, made a stroke at us with a stick, but did not hit either of us. As he was making another pass, I struck him down, and we entered the barrack and took 5 or 6 of those in the room and sent them off to the main guard. Got a candle and searched the room, found no arms, but a number of hickory sticks shorter and stouter than walking sticks. When the search was over, one of the British soldiers catched at the candle and put it out, and followed us to the other barrack, where he was insolent and saucy, and I thought proper to send him to the guardhouse. Gave orders to the British soldiers that they should not leave the barracks till the barracks were searched, telling them they should not be molested by my men. Searched the barracks where I supposed the gun was carried in. They were loath the barracks should be searched, and refused giving me any direct answers. They were insolent and kept damning of us. Several of them called us damned rebels, and Yankees several times. This gave me strong reasons of suspicion that the gun was secreted among them, and I therefore thought proper to send the greater part of those in that room to the main guard. Went on and searched several rooms in the same row of barracks and met with no opposition or insult. Finding the search fruitless, returned with my detachment to Winter Hill, except a party I left to reinforce the guard at the French lines. Colonel Henley. Did you receive any orders from me whatever that evening? No, I made report of the transaction to you next morning. General Burgoyne. Were you distinguished from the men by any mark that could designate you to be an officer of rank? I had on a blanket coat and sword slung over it with a firelock in my hand, and it was dark. Colonel Eliza Brooks. On morning of January 8th, made a report to Colonel Henley in the following words. Sir, before I make my report as an officer of the day, yesterday, I thought it my duty to inform you that one of your sentries was last night knocked down and his gun taken from him. That Colonel Garish, in attempting to recover the gun, was resisted with clubs, etc. That about 20 of the British soldiers were confined for this affair. I am this moment informed that 2 of our men were killed last night. Whether it be true or not, I can't say. Colonel Henley, had you orders to get your regiment under arms? The regiment were, I believe, got under arms immediately, and soon after dismissed, but I was not with them. Captain Caleb Brooks, on January 8th, was captain of the guard on Prospect Hill, and had in custody 29 British soldiers. About 11 o'clock, Colonel Henley and Major Swayze came up to the guardhouse, and after some inquiries and my reporting that everything was very quiet, Colonel Henley told me that a reinforcement was coming up, and he thought it would be best to take the prisoners out of the guardhouse and send them to Cambridge, where an inquiry could best be made into their crimes. We went into the guardhouse together, and presently the detachment came into the citadel, and formed about 4 rods from the guardhouse. Saw a large number of British soldiers collecting near the corner of the guardhouse. Went with Colonel Henley's orders to bid them disperse and retire to their barracks. He ordered them 2 or 3 times. Finding they would not obey him, he called 12 men from the detachment. After some time, the 12 men moved from the party, upon which the British soldiers gave a shout and dispersed, going off towards their barracks. Immediately on this, a man came up and told Colonel Henley that a prisoner had been rescued from him by the British soldiers. Colonel Henley said he would take the command himself, and then marched the detachment out of the citadel and paraded them in the rear of the barracks in the fort. Know of no transactions while the detachment were in the fort, for as captain of the main guard I could not quit my post at such a time. Near 300 British soldiers were collecting when they dispersed. No insult was offered to Colonel Henley by the British soldiers, but they were laughing and jeering at the guard. Some of them cried out, "Yankees!" I can't be particular in their expressions. General Burgoyne, was there any appearance of an assault on the part of the British soldiers? No, they appeared to me rather with a view of insulting than assaulting the guard. They pointed at and laughed at the guard. They were talking, but I did not hear their expressions. There was a breastwork between the British soldiers and the detachment, over which they were looking at the detachment. Had the British soldiers any weapons in their hands? Not that I saw. Major Swayze, on the morning of January 8th, was accompanying Colonel Henley to Prospect Hill. At the bridge on the road to Prospect Hill, the sentry was examining a pass showed him by Corporal Buchanan. Colonel Henley, suspecting the pass might be forged, ordered Buchanan to show it to him. With much reluctance, he gave it to Colonel Henley, the name of another man inserted in it. In consequence, Colonel Henley ordered a file of men to take charge of him, as there had been frequent rescues before. Colonel Henley ordered the guard, in case any British soldier should attempt to rescue him out of their hands, to fire upon them, then went on with Colonel Henley to the guardhouse on Prospect Hill. Soon after we got upon the hill, a detachment, which had been ordered up to take charge of some prisoners in the main guard, arrived. After the detachment had paraded near the guardhouse, a large body of British soldiers appeared near the breastwork, who were ordered to their barracks by an officer, and then by Colonel Henley. They appeared to move off slowly, stepped up to the breastwork, and observed Buchanan coming up with the guard. The guard had got into a crowd of British soldiers, observed a British soldier hold up the skirts of the coat of one of the guard, and heard some amongst them, the crowd, cry out, "Run, damn you, run!" and saw Buchanan running through the crowd of the British soldiers. One of the guard, pursuing him with the charged bayonet, was intercepted by the crowd, and I saw no more of Buchanan. Immediately, Colonel Henley ordered the whole of the detachment to march out of the fort, and we went out of the fort together, and Colonel Henley asked me what measures he should take to recover Buchanan. Observed to him the best way would be to acquaint the British commanding officer of the day of it, and did not doubt he would give Buchanan up. Colonel Henley then desired me to wait on the commanding officer and acquaint him with the matter. Accordingly, waited on Major Foster of the 21st Regiment, and on acquainting him with the matter, the major told me he would send for the adjutant of the regiment and order him confined, and report the matter to the brigadier. In 6 or 7 minutes, I returned to Colonel Henley and reported Major Foster's answer, with which he seemed perfectly satisfied. About 150 soldiers were assembled at the time Buchanan was rescued, within a circle of 100 yards. James Hartwell was at the guardhouse on Prospect Hill on the forenoon of January 8th, when Colonel Henley and Major Swayze rode up. Soon after, a detachment came up and were paraded near the guardhouse. A number of British soldiers made their appearance outside the breastwork, near the guardhouse. Orders were repeatedly given to them by the captain of the guard and by Colonel Henley to disperse, which they paid little regard to. There were about 100 at the breastwork, and more were coming up. At this time saw 2 or 3 of our men armed, coming through the British soldiers. Colonel Henley called out for a dozen men, upon which the British soldiers gave a shout and moved towards the barracks, and on their way rushed between the 2 or 3 armed men before mentioned, and there was a scuffle among them as they cleared away. Suppose a British soldier, by his clapping his hand near his hip, was wounded. Colonel Henley soon marched out with the detachment and paraded them in the rear of the barracks. I followed and stood in the rear of the guard near the center. As soon as the detachment halted, the British soldiers gathered round in front and rear of the detachment, to the amount of upwards of 200. Colonel Henley ordered 12 men on the right to prime and load, and then wheeled them to the left so as to form an angle. Colonel Henley then turned towards the British soldiers and said that he had had 1 prisoner rescued, and if they offered to rescue any more, he would order his guard to fire upon them. Colonel Henley asked for Major Swayze, and seeing Colonel Garrish on horseback, he stepped up to him. 2 or 3 British soldiers followed him and stood at 2-3 yards distance, listening to what was said by Colonel Henley and Colonel Garrish. Colonel Henley ordered a division from the left of the detachment to go into the citadel and bring out some prisoners. They marched off accordingly and were about 1/4 of the whole detachment. Colonel Henley disposed his men to receive the prisoners which might be brought. By this time the British soldiers had collected in such numbers that the colonel had hardly room to pass in front of his guard. Colonel Henley then addressed the British soldiers and ordered them to disperse and go to their barracks. Some few turned round. Colonel Henley repeated his orders and said, "Begone to your barracks, every one of you." Some others then turned round and moved slowly. Colonel Henley, on their moving slowly, cried, "God damn you, why don't you move?" and made a lunge with his sword at a British soldier, which I imagine struck him, as I observed the sword was bent, and saw the colonel endeavor to straighten it. They then moved off, and the men returned from the guardhouse with the British prisoners, and the whole detachment marched off the hill with them. Did not hear any British soldier say anything to Colonel Henley during the time. There was a buzzing amongst them, but I can't repeat any expression they used. The British soldiers had no weapons in their hands. The colonel might have taken a single person. It might have been dangerous taking more. After he made the lunge mentioned, he turned round and walked in front of his guard towards the right, and spoke to a British soldier, who was walking very slowly in front of the guard, and bid him go along immediately. He repeated the order. The soldier did not in the least quicken his pace. Colonel Henley followed him a little way and then turned round. The British soldier attempted to pass the sergeant, who stood on the right of the guard. The sergeant pushed him off the bank. Asa Pierce belonged to the militia. On January 8th in the forenoon, orders came to the sergeant of our guard to furnish a file of men and a corporal to take charge of a British soldier, of which I was one. We took him at the bridge, just below the provision house. Colonel Henley, when we took charge of the prisoner, buzzed by and gave us orders, if any man attempted to rescue him, to fire upon them. We marched on with him. His name was Buchanan. He told us he had done nothing more than having a pass that was not his own, that he should not be punished, and that one of us would be sufficient to guard him. Just as we got within the works behind the barracks, where there was a considerable number of British soldiers collected, a British soldier came up to us as upon the run, told him to keep off. He muttered something and told me, if I did not mind, he would take my firelock from me. Our corporal told him if he did not mind how he talked, he would take care of him. On this he stepped aside and walked along with us, talking with Buchanan upon the subject of his confinement. As we went along, we came up to a crowd of British soldiers. I should think 300 or 400 of them. Our corporal ordered them to make way, which they refused to do, and stood so thick together that we could hardly tell which the prisoner was. The prisoner stepped out, and another British soldier stepped in, took hold of Buchanan's arm, and placed himself between me and Buchanan, who went off with the crowd. Our corporal, turning round and seeing Buchanan gone, stepped in among the British soldiers to recover Buchanan. The same British soldier who had taken hold of Buchanan's arm took hold of the corporal and stopped him. Upon this I brought my piece down and pricked the soldier who had hold of the corporal between the hip and the ribs. The soldier then let go of the corporal's arm, and we marched on to the main guard without our prisoner. General Burgoyne, did the British soldiers refuse by words or actions to make way for the guard to pass? By actions, I mean they did not move out of the way. They talked, but I don't recollect what they said. After Buchanan had escaped from the guard, did the British soldiers show any marks of triumph? Yes, they laughed and huzzaed a good deal. Do you know the name of the person whom you pricked? I do not. Do you think you run the British soldier into the body? I imagine I did, for I pushed with a good will, and he cried out, "God damn you!" Several witnesses testified that the American sentries had been frequently knocked down on their post by the prisoners, and soldiers who were arrested were frequently rescued. It was common for the British soldiers to use every possible term of insult towards the American soldiers while on duty, and sometimes even to the officers. On one occasion, an American lieutenant made known to the British officers the circumstances of an insult and rescue of a very aggravated character. The guilty party was afterwards tried by a British regimental court-martial and sentenced to receive 50 lashes. But the sentence was remitted, and the man set at liberty, and no satisfaction was given to the American officer who had made the complaint. The standing orders from Colonel Henley to the Maine Guard, dated December 23, 1778, were as follows. The guards are to be vigilant and alert, and do their utmost to prevent disorder and keep peace. Ever attentive to the security of the camp. No officer or soldier shall be allowed to stroll from the guards. No offense to be given to any officer or soldier of General Burgoyne's army, nor is any to be received from them by the officers and soldiers of the United States of America. But they are to take up and confine any that offer the least abuse, and report them to the commanding officer. The officer commanding the guard will give orders to the sentries that they are to defend barracks, fences, and all property whatsoever belonging to the army, or to any of the inhabitants of the United States. When any insurrection of the prisoners shall appear to be of consequence, the commanding officer at Cambridge is to have due notice thereof. End of section 93. Section 94 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army, Massachusetts, 1778, Part 4. In rebuttal, Captain England, am an officer of the Grenadiers. August 1774 was member of a general court-martial at New York, whereof the late Brigadier General Nesbitt was president. Captain Adie of the Royal Artillery was judge advocate to the court-martial, and the Reverend Mr. Newburgh, chaplain to the 18th Regiment, was tried by the court-martial for various offenses and was prosecuted by Captain Chapman of the same regiment in the name of the regiment. After the witnesses against and for the prisoner were examined, the prisoner made a defense to which Captain Chapman, the prosecutor, made a reply, in which he commented and remarked upon the prisoner's evidence and defense, having been allowed a certain time to prepare his reply. Captain Willows belonged to the King's Regiment. Lieutenant Molesworth of the 52nd Regiment was tried by a general court-martial of which I was a member, at Quebec in the year 1769. After the prisoner had made his defense, Lieutenant Williamson, who prosecuted, replied and remarked upon the evidence produced by Mr. Molesworth. Lieutenant Bivy, am of the 24th Regiment, in the trial of Captain Garston of the 17th Dragoons in Dublin, in the year 1771. Major Birch appeared as prosecutor, and it being objected at first by the prisoner that the prosecutor should have the assistance of counsel, it was the opinion of the court that both the prisoner and prosecutor should, if they thought proper, have counsel to prompt and assist them, but not to plead. The judge advocate upon this trial was an attorney. Major Birch acted through the whole course of trial as prosecutor. The judge advocate, Mr. President and gentlemen of the court, this, in common with all courts of record, undoubtedly has power to direct its own proceeding, subject to the Articles of War. I do not ground my objection on anything in those articles, prohibitory of the claim I oppose, but on the customs which prevail in the American army and the supposed duty of the judge advocate. Those articles constitute a judge advocate, who, although enjoined to prosecute in behalf of the government, hath always been considered in our armies bound to assist the prisoner, not only in points of law, but by an impartial representation of facts. The whole evidence in the trial is taken in writing, subject to the inspection of the court. You cannot, therefore, gentlemen, be deceived by sophistry or misled by rhetoric. Pleadings for this reason are unnecessary, except on a point of law for which the judge advocate is presumed to be competent and unbiased by the tenure of his office. I do not oppose these precedents because they are British. Had they been from Portugal or Turkey and been pertinent and reasonable, they ought to influence your determination, although the instance mentioned by Lieutenant Bibby is rather against the general, considered in the latitude to which he aims to extend his claim. The articles of war which govern the British Army are extracted from the Roman Code of Civil Law, and ours are nearly the same with those adopted by the British Mutiny Act. The trials by courts-martial are designed to be simple, speedy, and decisive. The soldier's duty is clearly prescribed, and the punishment for neglect of it plainly ascertained by the articles which give jurisdiction to the court that are to inquire into and punish delinquency. The judge advocate acts in the double capacity of prosecutor and counsel to the prisoner, which those who are acquainted with the proceedings of military courts will allow not to be inconsistent duties. The office of judge advocate has been considered by some in an army the same as that of Attorney General in the courts of criminal jurisdiction at common law. But I can safely appeal to your decision, gentlemen, if I am wrong as to the duty of that officer in our army, as I have laid it down. The altercations of the bar in the courts of common law arise from a combination of rights in free society, which are unknown in an army. A man, when he commences a soldier, makes a temporary relinquishment of the privileges of a citizen. If a prosecutor, and in this case a very able one, is admitted in addition to the judge advocate, surely it would be unreasonable to deny counsel in defense of the prisoner. And then consider, gentlemen, what would be the consequence. Every man brought before a court-martial would be entitled to the same indulgence. All the subtleties and delays which prevail at common law would be introduced into courts-martial, infinitely to the public disservice, under the circumstances which armies, durante bello especially, ought to be maintained and governed. I submit my objection to the opinion of the court. The court was ordered to be cleared, and after debate announced their opinion that General Burgoyne should have the liberty of remarking upon the evidence offered by Colonel Henley, and the judge advocate was directed to acquaint the general with this determination. End of section 94. Section 95 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army. Massachusetts, 1778, Part 5. January 24th. The court now called on Colonel Henley to close his defense. Colonel Henley: Mr. President and the gentlemen of the court, I have particular reasons, and in my own apprehension very sufficient, for declining to say a single word in answer to the illiberal abuse thrown upon me, and the palpable dishonor done to my country by General Burgoyne in this court. It is, Mr. President, a new thing under the sun, and taken in all its circumstances, totally without example. The judge advocate will sum up the evidence with ability and impartiality. Such is my consciousness of having done nothing through this whole affair, but what the honor and safety of my country absolutely required, that I shall rest entirely satisfied with your decision, being at the same time fully persuaded that the impartial public, at whose bar I stand, will join with you in acquitting me from all the injurious and illiberal charges of General Burgoyne, and that they will vindicate me for that humanity, characteristic of an American officer, and with which the officers and soldiers of General Burgoyne's late army have been treated, while I was honored with the command of the Guards. General Burgoyne, Mr. President and Gentlemen of the Court, on the day of your last adjournment, the Judge Advocate notified me that the Court had agreed I should reply to Colonel Henley's defense, but had directed that the reply should be made immediately after the Colonel closed. He added that all interested are to attend and come prepared. I did not judge from the manner in which the Court have treated me hitherto that in any instance they meant me uncandidly. I therefore suppose that when they made it a point I should come prepared to answer, offhand, arguments which might have been a month in framing, they saw the evidence before them in so strong a view that no argument on my part could be necessary. Did I want further confidence in this opinion, I could not fail of deriving it, in a most ample degree, from the conduct of the prisoner, who has just been now constrained by his situation to substitute invective for argument, and to recriminate where it was impossible to defend. Under the sanction of the Court and the circumstances of the time, this candid gentleman has ventured to make use of terms to which my ears have not been accustomed. But he is mistaken if he thinks to draw from me an intemperate reply. On the contrary, as conductor of this prosecution, I have rather to thank him for his assistance. After having furnished me during the whole course of what is called his defense, with evidence to corroborate the facts alleged against him, he at last steps forth a volunteer witness, the most undeniable one, sure, that ever came before a court, to prove the heat of his own temper, which is of itself a material part of his accusation. This remark is the only return I shall at present address to the prisoner for the expressions he has used, but I cannot quit the subject without seriously appealing to the recollection of the Court, whether, from the outset, I did not, in the most positive terms, disavow all personal resentment, and whether the strongest language which the course of my duty as prosecutor led me to use did not invariably arise from the facts and apply to the offense more than to the offender. I make the same appeal against the accusation of having done palpable dishonor to the country in this court. Is it to do palpable dishonor to a country to appeal to the justice of it? It puzzles my intellects to conceive the meaning of this last expression. But indeed, sir, I want no other vindication than your silence, to prove that I have not abused the latitude I have possessed in either case. For would you, Mr. President, or any member of the court, have suffered a prosecutor to insult an unhappy man under trial with illiberal abuse? Still less would you have suffered the country to be treated appropriately. It is for Colonel Henley to reconcile with his respect to the court charges which, if founded, would be a general reflection upon their conduct. I understand great expectation has been raised of a very elaborate defense on the part of Colonel Henley, and acknowledge I myself little thought he would throw up his cause quite so confessedly, though I was always sure that neither ingenuity nor sophistry, nor all the talents which the ablest counsel could assist him with, would be sufficient to effect the great leading proposition upon which I ground myself, as upon an immovable rock, namely, that the proofs on the part of the prosecution do not only remain unimpeached, but are augmented and enforced in the most material parts by the evidence produced in the defense. Gentlemen, a very few observations will suffice to justify this assertion. The first part of the charge which the prisoner brings evidence to oppose is that concerning Corporal Reeves on the 19th of December, and the first evidence is Major Swayze, an officer of rank and trust in your army, warm in the present unhappy contest and naturally impressed with inclinations to favor his countryman, his brother officer and friend. Yet, with all these circumstances to bias, such is the force of truth and honor upon that gentleman's mind, He proves to be the strongest witness of the whole trial, on the side of the prosecution. The beginning of this gentleman's relation is a confirmation of all the leading circumstances mentioned by the other witnesses. The first new matter of evidence is that when he, the major, told Reeves he was a rascal, the corporal made a reply to him, not to Colonel Henley. He was no more a rascal than he was, at which he raised his whip and told him if he did not hold his impertinence he would strike him. One circumstance of this part of the evidence cannot pass observation, namely, that the poor corporal had two addresses to answer instead of one. The word and the menaces attending that word rascal came to his ears on both sides. Another circumstance is equally observable, and it stands upon your proceedings as a record of honor to Major Swayze, that his warmth of temper was moved at the recital of Reeves' offense, to give a sharp rebuke, and to use an opprobrious expression, but the idea of chastisement went no further than a stroke of the riding whip. Happy had it been for the prisoner had he followed so temperate an example. The major's narrative proceeds in respect to Colonel Henley's dismounting, catching the firelock, and stabbing Reeves, in conformity to all the witnesses for the prosecution, except that the circumstances of ordering one of the guard to run the corporal through is omitted, and his recollection being called to that circumstance by a question in the cross-examination, he replies he did not hear him, but with a candor and tenderness to his oath which never departs from him, he adds, he might have given such an order, and I did not hear it. The foregoing evidence, therefore, is not shaken by any contradiction, but it is immediately after augmented by an entire new circumstance, namely, that after the first thrust, upon Reeves still talking to Colonel Henley, he stepped back and made a motion to cock the firelock, and added he would blow his brains out, or words to that effect, when a British soldier took hold of the firelock and threw it up. I request the court to take notice that Major Swayze, uncalled upon by any leading question, remembers that act which saved Reeves from a second thrust, accompanied perhaps with fire. Can any doubt be now entertained of Colonel Henley's resolution? I think I have proof they were obvious to Major Swayze at the time, by the very remarkable part of the evidence. I then got off my horse, a conduct worthy his character, expressive of his apprehensions and his humanity, and begged Colonel Henley to send Reeves to the guardhouse. The other petitioners joined their intercession, and the man's life at last was saved. It may perhaps be objected to this argument that Major Swayze, upon being asked in the cross-examination whether he thought Colonel Henley made a thrust with an intent to injure or to silence the corporal, answers to silence him, for if he had pushed his arm forward he would have run him through, and in another place he makes use of the words to still him. I scorn to insinuate that a witness of the Major's description meant to keep a salvo upon his mind, and purposely to use any term of ambiguity. I upon my honor believe that when the Major makes use of the words to silence or to still, he means to terrify him till he held his tongue. But I beg leave to observe that great difference might be made in the Major's opinion between the time the act was committed and the time his sentiments are asked in court. The conversation with Colonel Henley, the belief of his other friends, and the candor of his own heart now persuaded him that the Colonel's intents were innocent. His own interference and intercession marked his doubts, at least at the time, and did they not, the court will hold themselves bound to act upon their own opinion, formed upon combination and comparison of circumstances, and not upon the opinion of another, which is no evidence. They will also recollect that this opinion goes only to the first stab, and is formed upon its not being forcible. It does not appear that the Major formed any opinion, nor indeed could he, upon what force would have been the second stab of a man rising in a passion, had it not been prevented by seizing the bayonet and his intercession. It is not necessary to trouble the court with the review of any other parts of this upright evidence, which is long. The answers to the cross questions in general go to a full confirmation of the narrative, with this one addition and aggravation of Colonel Henley's conduct, that the Major thinks the language of Reeves was addressed more to himself than the Colonel till after the stab. Captain Wild of the militia is the next witness and confirms the excuse of Reeves and every other circumstance in the beginning of the affair, as stated by the former witnesses and by Major Swayze, except the small difference that Colonel Henley, not Major Swayze, first made use of the word rascal. He mentions afterwards another new circumstance that the prior witness had forgot, namely, Reeves turning to Buchanan and damning him, saying, "Why don't you stand up for your king and country?" Buchanan desired him to be still. Reeves replied, "God damn them all. I'll stand up for my king and country while I have life. If I had arms and ammunition, I would soon be with General Howe and be revenged." He afterwards relates in a very circumstantial manner, making the push at Reeves. Reeves stepped back 1 foot, but the bayonet pricked him, and the lifting up the piece a second time, and Buchanan seizing it and turning it aside. Upon the cross-questioning, the witness gives nearly the same answers as Major Swayze upon the matter of opinion of Colonel Henley's intention, and of not hearing Colonel Henley order a man of the guard to run Reeves through before he dismounted, but repeating the first, the manner in which this gentleman expresses himself is remarkable. "I believe you only meant to silence him, as you spoke mildly, till Reeves said, 'God damn them all.'" That Captain Wild thought the colonel was in a passion afterwards is clear from his answer to the question whether it is a rule in the Continental Service to silence men by the bayonet or sword, when he replied, "It is not, but when a man's temper is raised, he is apt to do things he would not at other times." I cannot quit this evidence without classing it with Major Swayze's, and while it does honor to the witness in point of truth and candor, it is to be remarked that it is also exceedingly circumstantial. New and leading circumstances are remembered, none forgot, except the order of the guard, and the court will see by and by why I so solicit their attention to these remarks. The witnesses that follow are indeed of a very different sort. The court will recollect the appearance of the first, Corporal Dean. He told his story very fluently, with that remarkable new incident of provocation in Corporal Reeves, who, he swears positively, said to Colonel Henley, "If I am a rascal, you are a damned rascal." But after all this fluency and recollection, upon his cross-questioning, neither encouragement nor admonition nor patience nor leading question could draw an answer that any man could understand, and particularly the court will remember his silence and his countenance when pressed to declare his sentiments upon the obligation of an oath. I will not be so uncandid as positively to pronounce upon guilt from appearance, but it is the great value of parole evidence that a court may see the manner and thence form a judgment upon the credibility of a witness. From what probable cause did the confusion of this man arise? It was not the awe of the court, and it is fair to suppose it is a weakness of understanding. Consequently, he was a fit subject to be tutored, and if not willfully perjured, led into a belief of more than he actually saw and heard. He is followed by a string of the best instructed young men that ever related a story in public. Elijah Horton, Silas Moss, James Brazier, Wordsworth Horton, and John Benny, most of them lads of 16 years of age. I need not recall to the court the precision of the recital of these youths, nor the manner of their delivery. It was the exact tone and repetition of a fable at school, and so well was the lesson got by heart that there was not a single difference in the arrangement, and scarce a syllable misplaced. But it is not only in the similitude of memory these youths are extraordinary, they are equally remarkable in the precision of their forgetfulness, with a recollection so acute as to repeat verbatim a long story of Corporal Reeves, and the marked expression, "damned rascal," to Colonel Henley. Not one syllable was heard by any British witness, nor by those attentive, circumstantial, respectable witnesses, Major Swayze and Captain Wild. Not one of the whole 5 can remember a word or circumstance respecting the Colonel's damning Reeves, King, and country. Attempting a second pass and being prevented by Buchanan seizing the firelock, to all of which all the other witnesses had positively sworn. Upon the whole, I contend that no contradiction of witnesses could invalidate their testimony more than such an exact conformity in circumstances, sentences, and words, when it was for the purpose of 5 persons to recollect the same story, and with equal conformity in the want of recollection in circumstances that must indispensably have been as manifest to their observation as to that of any other witness. I owe an apology to the court for having dwelt upon the invalidation of these witnesses longer than was necessary, for the weakness of their instructor, whoever he has been, has counteracted his wickedness, and it would do no harm to this prosecution to give a full scope to their testimony, because there is no maxim in law more clearly laid down, and more generally understood, than that no affront by words or gestures only is a sufficient provocation, so as to excuse or extenuate such an act of violence as manifestly endanger the life of another. The next matter to which the witnesses in defense have gone is the stabbing of Traggett on the 8th of January, and there likewise their testimony is served to aggravate, instead of contradicting the charge. Sergeant Kettle, in particular, expressly says he thought the soldiers deserved stabbing, as they would not get out of the way, and in another place that laughing and sneering, as it were, which he acknowledges was the only provocation, was sufficient to justify stabbing. I shall give the court no trouble upon the evidence brought to prove the provocation of a rescue. The escape of Buchanan was not heard without a smile in court, nor can it be seriously commented on, except in the answer of Asa Pierce, a lad of 16, to the judge advocate, who asked him whether he thought he'd run the British soldier into the body. "I believe I did," says he triumphantly. "I pushed as hard as I could, and with a good will." He cried out, "God damn you!" This is but one of several instances that might be selected from these proceedings to show the degree of rancor to which the minds of the American soldiers were excited. Children that had scarcely lost the taste of their mother's milk acquired a thirst for blood, among those from whom they took the example. The colonel thinks a man deserves death if he looks sulky. The sergeant thinks the same if he smiles. Good God! What is the value of a British life at such a time, in such hands? In a former part of these proceedings, I expressed my desire that the judge advocate would explain to the court the established principles of law respecting absent persons being accessories to offenses which they have in any manner influenced, and almost every sentence that has fallen from the last witness upon the affair of Traggett is a new call to press the consideration of those principles. I am persuaded the learned gentleman will not contradict me. In the few more leading propositions I shall add to those I mentioned on a former occasion. First, any man advising, influencing, or countenancing another, be it by words, reward, or example, to do mischief, is an accessory at a distance. Secondly, though mischief is committed by different means than those proposed between instigator and perpetrator, for instance, A persuades B to poison C. He kills him by any other means. A is accessory. Thirdly, when the principle goes beyond the term of solicitation, if in the event the mischief committed was a probable consequence of what was ordered or advised, the person giving such orders or advice will be accessory. Apply the above maxims. Colonel Henley directs his men only to knock down any British soldier who they think looks sulky at them. You have seen that he often thought a much greater punishment was due for such a crime as a sulky look. But we will suppose he only orders them to knock a man down, or to prick him or still him, and a soldier fires down a common road. sticks his bayonet into one, and strikes at the brains of another with the butt of his firelock. Colonel Henley is a party to the mischief, whatever it may be, and upon a continuation of the principle laid down before, the advice, orders, or influence of litigious on the part of A, the events falling out beyond his original intention, are in the ordinary course of things the probable consequence of what B does under the influence, and at the instigation of A, and therefore in the justice of the law, he is answerable for them. So much, sir, for the enormities committed under the orders, influence, encouragement, and example of Colonel Henley, when he was not present. As for the rest, it is needless for me to follow the witnesses brought by the Colonel through all the parts, wherein they separately and distinctly confirm the former evidence upon the charges respecting the attempt upon Wilson in the Colonel's sight, and of the stabbing Henley with his own hands. I shall only remark one very striking circumstance, a little previous to the latter fact, which came out upon the second examination of that very honorable and sensible gentleman, Major Swayze. After Buchanan had run away, Colonel Henley, having first ordered some men to load and put himself at the head of the whole detachment, asked Major Swayze what method he thought they should take to recover Buchanan. The Major said the best way would be to acquaint the British commanding officer on the hill, and he made no doubt but he would give him up immediately. The Major went with the message from Colonel Henley to Major Foster, the British officer then commanding, who ordered the man to be sought for and confined. I state this circumstance to show not only what was the proper and ready method of avoiding differences and ill blood in fact, but also to show that this method was proper in the judgment of your own temperate officers. The Major proceeds to say that Colonel Henley appeared perfectly satisfied with the answer he brought from Major Foster, but it is well worthy of remark that the violent act of stabbing Henley was committed in the interim of Major Swayze's leaving Colonel Henley and his return. The whole stress of the evidence upon the defense I have not remarked upon, goes to one single point, namely, to prove provocation. I have admitted that a sentry was knocked down, as I readily admit every slight of provocation alleged, and shall not give a moment's trouble to the court, in addition to what I argued and quoted in a former part of the proceedings upon this subject, from undeniable authority of law. I assume it to be undeniable, because I understand, gentlemen, that the criminal and common law of England, as well as a great part of the statute law, are, notwithstanding your present separation, in force and practice in your government, and that your articles of war are almost transcripts from ours. The maxims, then, to which I have alluded, will hold equally good in martial and other judicatures. I have only, sir, to refer to the leading proposition, and affirm that the charge is approved in the fullest manner, even by the prisoner's witnesses. It is not for me to suggest an opinion upon the nature of punishment. I scorn the idea of feeling joy from the most rigorous sentence, and the most perfect acquittal would not harm me further than that such an example might continue the insecurity of the troops. Inflexible and impartial justice and rigid discipline are the vital principles upon which a republic rises to maturity and establishes itself in respect and fame. Should the court, upon due reflection, find these principles reconcilable with lenity in the present case, and the great tribunal of the world be of a contrary judgment, this cause cannot be said to have miscarried. As to the displeasure which this prosecution may bring upon me, I fear in the present temper of this part of the country it is not to be avoided. I stand in this circle, at best, and unpopular, with the sanguine enemies of Britain, perhaps an obnoxious character. This situation, though disagreeable, does not make me miserable. I wrap myself in the integrity of my intention, and can look around me with a smile. Implacable hatred is a scarce weed in every soil, and soon is overcome and lost under the fairer and more abundant growth of cultivated humanity. To the multitude who only regard me with the transient anger and political opinions in the occurrence of the time occasion. I retain not a thought of resentment, because I know the disposition and hour will come when steadiness of principle, that favorite characteristic in America, will recommend me amongst my worst enemies. As Christians, I trust they will forgive me. In spite of prejudice, I know they will respect me. But from the present resentful sentiments of this audience, should I carry my apprehension further, and suppose it possible that misapprehension or misrepresentation of my conduct should operate upon the supreme rulers of this country to treat me with severity, I hope I should still find myself prepared. Let suspension be added to suspension, and health and fortune and fame and life become successive forfeits in this lingering war. I shall lay at last down my devoted head with this consolatory reflection, that I have done what I ought, that I have performed to the best of my power my duty to my country, to the British troops under my charge, and to myself. And above all, it will be consolation to reflect that, however misinterpreted or abused, I have acted in all instances, and specifically in this trial, without a spark of private malice towards any individual soever. With this declaration I opened, with the same I conclude, and have only to assure the court of my acknowledgments for the patience, the attention, and the civility with which they have heard me. End of section 95. Section 96 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. Trial of Colonel David Henley for improper conduct as an officer of the American Army. Massachusetts, 1778. Part 6. January 25th. The Judge Advocate. Mr. President and gentlemen of the court, it remains with me to close this cause which has employed so much time and been the subject of such public expectation. The mode of inquiry established in all trials by courts-martial necessarily renders the process tedious. This has been particularly so, and was an apology wanting, the patience exhibited by the court through the whole course of it would atone for the hours spent in the investigation of the subject. This cause, gentlemen, has been rendered important rather from the distinguished rank and peculiar circumstances of the very able prosecutor than from the real merits of it. For, however it may have been insinuated that Colonel Henley was appointed commandant of the garrison at Cambridge for the purpose of executing the bloody designs of an irritated, vindictive, and sanguinary people, I believe the public as well as the court will consider the prisoner as alone interested in it, and that this trial must forever stand the clearest refutation to anyone hardy enough to repeat an assertion as injurious as it is false. No sooner was the charge handed to General Heath, the guardian of the public military reputation in this department, than Colonel Henley was suspended from his command, and an immediate inquiry ordered into his conduct. Yet, notwithstanding this prompt, this early endeavor to discover facts and punish if criminality should be proved, a wound has been aimed at the reputation of this country. It has been said, gentlemen, before a respectable and crowded audience, that a general massacre of the troops of the convention was in contemplation, and Colonel Henley fixed upon as the black instrument of execution. There was not an American present at that time, I dare assert, who did not feel indignation beat in every pulse, while his heart reprobated the idea. This charge, heightened with all the pomp of words which Attic diction and tragic eloquence could furnish, painted in those vivid animated colors which keen feelings and lively apprehensions would supply, wanted nothing but truth to have answered the design proposed, and that this was wanting you, gentlemen, from the evidence now on your table, are, I presume, convinced. The world hereafter may be satisfied. If I thought General Burgoyne, when making this assertion, sincerely believed it to be true, though I should wonder at his deception, I should have a better opinion of his fairness, and while we smiled at his panic, we might pity his timidity. Whatever particular personal reasons for gaining popularity or securing the affections of his army, or great political motives may have actuated the prosecutor in this business, you, gentlemen, who are to judge upon oath as well as upon honor, the two strongest ties that can bind you as men and as soldiers, will be swayed by nothing but the sacred principles of truth and justice. It is my duty to exhibit facts as they arise from the evidence, stripped of the meretricious coverings which ingenuity and rhetoric have attempted to conceal them. However excusable it may be in General Burgoyne to take a partial survey of the cause, by well-turned periods to catch the attention and force the admiration of listening crowds, and by a brilliancy of expression or affected nobility of sentiment, attempt to dazzle, the more effectually to mislead the court, the judge advocate has a very different part to act. He ought to know no party, but undeviatingly to follow the road marked out by truth alone. The difficulty of keeping the mind unbiased in this cause will strike the minds of the court. This is the trial of a gallant and meritorious officer, of a man whose services in camp and in the field most of you gentlemen have been witnesses to, and whose conduct as a citizen previous to his commencing the soldier was ever irreproachable. I must then depend on the candor of the court, should I err in summing up the evidence, to restore me to the path of disinterestedness. Much is due to the character of such an officer, but more to the safety of thousands, who, disarmed and in our power, are entitled by the laws of nations, of wars, of humanity, and of justice, to protection and security, provided no malcontent on their parts works a forfeiture of these rights. Fiat justitia ruat coelum. Let us now look into the evidence. The court will adjudge the blame to fall where it ought. It appears that Colonel Henley, on the 19th December, in consequence of orders from General Heath, visited the Maine Guard with Major Swayze, with the design of releasing a number of British soldiers who had got into custody for different misdemeanors. That he was calm and good-humored and proceeded to execute his instructions in the most suitable way, that of inquiring into the respective offenses of the culprits, previous to their dismission, and cautioning them against conduct which might subject them to another confinement. Reeves, in turn, being asked the cause of his commitment, with some hesitancy informed the colonel, and from his own account it appeared he had grossly affronted an American officer, that even the nerves of the candid, the placid Major Swayze grew irritated, and he was provoked enough to give Reeves a very resentful answer. Colonel Henley's feelings being more keen, he called Reeves a rascal. Reeves retorted the epithet, and the colonel, after repeatedly ordering silence, in order effectually to stop a very harsh altercation which had ensued, dismounted from his horse, seized a gun and fixed bayonet, and pricked Reeves in the breast. It appears from the concurrent testimony of all the witnesses on the side of Colonel Henley that his design was rather to silence Reeves than to wound him, rather to convince him he would be obeyed than to injure him. The extreme slightness of the wound, which from the surgeon's account was little more than a scratch, confirms this to have been the colonel's intention. It would certainly have been better to have remanded him to the guardhouse, and if, gentlemen, you think the witnesses in support of the charge have told you all that really passed, you ought at least to think that Colonel Henley is a rash, passionate, precipitate officer, a man who considers stabbing his fellow creatures as a very venial offense. But if full credence is given to the evidence of 6 witnesses, the court will consider whether an officer, acting in such a character as the colonel then appeared in, so saucily and abusively replied to by a prisoner in brief circumstances, is not pardonable, I do not say justifiable, in adopting such a mode of silencing impudence and repressing contempt. It has been said that Lee's behavior was only firm, not insolent. British firmness often so nearly approaches insolence that Europeans as well as Americans have been very apt to confound them. The court will recollect the pains taken in one or two instances during this trial to get from the British witnesses their idea of insolence. They all affected to think it impossible a Briton could look insolent. It was, they said, only looking up. But this sublime, this erect countenance they boast of, leads them to looking down upon the rest of the world, though not always with impunity. Britain is feared because she is powerful. What pity it is a nation cannot be just as well as gallant. Lest pride had prevented the dismemberment of her empire, had saved the blood of thousands, and real magnanimity had, ere this, arrested the hand of destruction from the heads of men, whose greatest fault, once the glorious fault of Britons, is the love of freedom. As to the charge against Colonel Henley of intentional murder, there was neither law nor fact to support it. But, says General Burgoyne, Colonel Henley's conduct had a great effect on his guards. He was known to be no friend of the British soldiers. He had himself wounded one and been violent in his menaces against them all. He thus influenced his soldiers to stab and murder whom they pleased, if they belonged to the British Army, and ought therefore to be considered as an accomplice in every outrage which took place. If this reasoning is conclusive by the same logic, the general himself is an accessory to all the murders perpetrated by the ferocious bipeds, the savages who accompanied and disgraced his army last summer. Ought it to be said that because these black attendants knew that General Burgoyne did not love Americans, that therefore he would be pleased at the butchery of the nerveless old man, defenseless female, and infant prattler? Because he hated rebels, he therefore influenced Indians to massacre that young unfortunate, the inoffending and wretched Miss McCrae. We now come to the last and principal transaction of the 8th of January, the wounding of Hadley on the parade. It will be necessary to state the circumstances anterior to this unfortunate action. You had the fullest proof, the confession of the prosecutor, that a sentinel on the evening of the 7th was knocked down on his post, that he was beat, disarmed, and his gun carried off. Colonel Garish, like a true-spirited officer, upon hearing of this daring outrage, determined immediately and in person to discover the British soldiers who were concerned in it. He accordingly, with a party of his regiment, surrounded one of the British barracks, and after some opposition, searched several rooms which appeared suspicious. The conduct of a number of very obstreperous fellows, which he found in one of the rooms, strengthened his suspicion, and he thought proper, after being assaulted, menaced, and insulted, to send several of them to the Maine guard. The transactions of this evening were reported to Colonel Henley next morning with aggravation. The colonel, finding he had got so large a number of British soldiers as 29 prisoners in the Maine guard, which was situated so near the barracks of the British Army that some difficulty might arise, adjudged it most prudent to remove all the prisoners up to the town, where a proper inquiry could be made, the culpable punished, and the innocent dismissed. A detachment of 100 men were ordered to the Maine guard for this purpose, and the colonel with the town major set out for the hill to see that the detachment did their duty. On his way down, he met Buchanan playing off upon a sentinel the evasive trick, which had now become common with the British soldiers, that of escaping from their barracks under counterfeit or borrowed passes. The colonel gave the orders respecting Buchanan we have before read, and proceeded on for the Maine guard, not with the most agreeable feelings, if we suppose the irritation which a variety of offensive reports and provoking considerations must have raised in his mind during the course of the morning. Soon after he got to the Maine guard, the detachment marched into the citadel and formed near the guardhouse. By this time, a very large body of British soldiers had assembled near the guardhouse. Captain Brooks says to the number of 300. The colonel, apprehensive that some disorders might arise, when the British prisoners should be sent off with the detachment, ordered the British soldiers to disperse. Finding he was not likely to be obeyed, he called for a dozen men from the detachment, which produced a movement among them, and they were going off. When just at this time Buchanan was rescued within sight of Colonel Henley. This act of insolent triumph determined Colonel Henley to take the immediate personal command of the detachment, which he instantly marched out of the citadel upon the parade in the rear of the barracks. He had hardly time to halt his men before he was surrounded by the British soldiers, who amounted to near 200 men, which was double his number. I rate the number on a median between what they were said to be by the witnesses for the prosecution and those in behalf of Colonel Henley. Consider now, gentlemen, what must have been Colonel Henley's sensations. At the head of a party of militia who, from being daily affronted by the British soldiers, were become their jest, that it had at length become absolutely necessary to convince these Britons that there was energy enough in their guards to force obedience and curb licentiousness, that a tumult had arisen the night before, and that an act had just taken place which was a defiance to himself, that he had not room to maneuver his men without great difficulty, owing to the British soldiers pressing in upon the party, and that these were most of them the very men who had just before been laughing at the party while paraded in the citadel, and who, in contempt of his orders, were again collected to keep up the laugh at the expense of the detachment. I put it upon this footing because I think it was apparent they were assembled rather to insult than to assail the party, though they were so near that it was only stretching out their arms, and it would have been easy to disarm the detachment by a sudden movement, especially after the colonel had detached a quarter of his whole party to bring out the prisoners from the guardhouse. Under these circumstances, gentlemen, and still more so, if he was apprehensive of an attempt to disarm his men, how extremely difficult must it have been for the colonel to have checked his resentment, or stopped the hand which had been so repeatedly and insolently defied. The colonel had told them he had lost a prisoner, threatened to fire upon them, and given reiterated orders for them to disperse before he made the lunge at Hadley. It has been proved that the British soldiers in general were slowly moving off at the time, but not that Hadley was one of them. If you are convinced, gentlemen, that he was going off, you will then consider how far the colonel's impetuosity is reprehensible, and punish him accordingly. It appears clearly that the British soldiers had no weapons of any kind in their hands, that they made no attempt on the guard nor struck any of them, from which it may be a question whether, had Hadley died of the wound he received from Colonel Henley, the colonel would not have been guilty of murder, because, upon the principles of municipal law, words alone, however impudent or provoking, will not reduce murder to manslaughter, though a very slight blow first given by the person killed might have made the killing manslaughter, or even a less species of homicide. If the nice distinctions of common law are to be made the rules of conduct in military discipline, and the regulation of a garrison, Colonel Henley must suffer. But I imagine, gentlemen, you will hardly admit this to be true, because soldiers and citizens are entitled to very different privileges. In an army, the disobedience of an order is sometimes punished with instant death, and such an action justified and applauded, which, was it to take place among citizens, might subject a man to a halter. Colonel Henley had stood for some time first in the citadel, and afterwards on the parade at the head of a detachment armed, and heard the provoking epithets of Yankee and rebel very liberally thrown out against his guards by the Scotch and British loyalists who surrounded him. The word Yankee, when used by these proficients in abuse, is intended to convey the idea of clownishness and cowardice, and to call a man Yankee rebel is considered by them as the strongest term of invective. Where is the officer in such circumstances who could suppress his indignation upon such an occasion? If, gentlemen, you should be satisfied that Hadley, at the time he was wounded, was moving off, You will consider whether Colonel Henley is not very blameworthy for making a violent lunge into a man's body who was obeying his orders and getting out of his way. Should you be convinced that Henley was not removing, though such peremptory repeated orders were given him with his comrades to retire to their barracks, your opinion will be different. Mr. Bibby swears that on the morning of the 8th January, as he passed over the parade where the detachment was drawn up, he heard an officer, whom he took to be the captain of the guard, damn his men for inattention and ordering them to run any man through who came near them. This speech appears to have been made soon after the wounding of Hadley, while the passions were in a tumult, and the pulse beating high from what had passed. The order was rash and unjustifiable, and the court will consider whether the example just set by Colonel Henley in stabbing Hadley did not occasion it, and how far he is accountable for encouraging sentiments of such nature. The instance mentioned by Colonel Lind of the sentries firing on 3 camp women cannot by any means affect Colonel Henley, because it does not appear that he ever gave such orders, nor was any report made of it to him. But surely it would be unreasonable to make the commandant of such a garrison as this, where the guards are made up of a young and inexperienced militia, unskilled in military science or duty, accountable for all the mistakes and violence of such soldiers. Had a complaint been made to him of this action, and he had refused taking notice of it, it would undoubtedly have been such an avowal of it as to have made him responsible for all the consequences of it. The expressions and violent menaces which Fleming and Wilson swear they heard Colonel Henley throw out at the Adjutant General's office on the 16th December carry with them, prima facie, very strong marks of malice and a heart boiling with the most vindictive and turbulent passions. But the court will recollect that the colonel had that morning a report of Mason and Crane being knocked down and disarmed, while one of them was on his post. They were both much beaten. It does not appear what led to the conversation, but Colonel Henley was relating the affair to some officer in the office when the sergeant came up and met with the salute, which has been laid before the court. The greeting was rough, to be sure, but might not the meaning only be that the devil had got into their barracks and possessed the occupiers of them, and that he should turn exorcist some night or other, turn the barracks inside out, and expel him from their territory? But I mean not, gentlemen, to palliate this matter. The words are before you. You are the judges, and will determine how far the sentiments expressed were malicious, and afterwards as such acted upon by the colonel. I will not take up any of the court's time by remarks on the evidence of the different rescues that took place from the beginning of December to the 8th of January, except of that sworn to by Lieutenant Stearns. This officer, after being insulted in the grossest manner by words and gesture, after having the fellow who gave it rescued in his sight, and after complaining through tenderness to the man's own officers, proving the complicated charge against him, to be then trifled with by a promise of a proper punishment being inflicted on the aggressor, and after all to have the fellow set at liberty unpunished, proves the necessity of exercising the right set up by General Heath of punishing the offenders of the convention troops, who could thus commit enormities with impunity, and shows in how contemptible alike the officers of the guards were held by the British Army, and the expediency of convincing them that there was spirit enough to resent injuries and energy enough to chastise offenders. I shall now submit the cause, gentlemen, to your decision. Many observations have been omitted which might have been pertinent, but which have doubtless occurred to the minds of the court, particularly with respect to the characters and contradictions of the witnesses, and I doubt not your judgment will vindicate the justice of our country, and be approved by the honest and impartial wherever it shall be known. The judgment. The court was ordered to be cleared, and upon mature consideration decided that the charge against Colonel Henley was not supported, and that he be discharged from arrest. General Heath approved this decision and ordered Colonel Henley to resume his command at Cambridge immediately. In the general orders announcing this result, he said, "The general thinks it to be his duty on this occasion to observe that although the conduct of Lieutenant General Burgoyne as prosecutor against Colonel Henley in the course of the foregoing trial and his several speeches and pleas may be warranted by some like precedents in British court-martials, yet as it is altogether novel in the proceedings of any general court-martial in the Army of the United States of America, whose rules and articles of war direct that the Judge Advocate General shall prosecute in the name of the United States, and as different practice tends to render courts-martial both tedious and expensive, he does protest against this instance being drawn into precedent in future." End of section 96.
Section 97 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 3 by John D. Lawson. The Trial of Jonathan Walker for Aiding Slaves to Escape, Florida, 1844. The Narrative. Captain Jonathan Walker was a native of Massachusetts, a shipwright and a sailor. The summer of 1844 found him in Florida in command of a small vessel whose alleged object was the raising of a wreck in Pensacola Bay for the sake of its copper and cargo. But his connection with a New England anti-slavery society and his subsequent statements and writings make it certain that his real mission was to assist fugitive slaves in Florida to escape to the Bahama Islands. He anchored near the shore and let it be known to the blacks that if they chose to run away he would take them. And on the 22nd of June, 7 slaves took advantage of his offer and came aboard. He at once set sail, but the weather was bad and very little progress was made for several days, and before they could get away from the coast, they were overhauled by a couple of small sloops, and the whole party conducted to the Keys, from whence they were taken back in a government vessel to Pensacola. Here he was confined in jail for several months, as he was unable to furnish bail. His guilt was easily proved. He was convicted on 4 different indictments and sentenced to branding, the pillory, fine, and imprisonment. He again remained in jail several months, until the money to pay his fine was received from his abolition friends in New England. He got safely home to write a book on his experiences in Florida and to be the subject of a poem by Whittier. The Trial. In the United States Court, Middle District of Florida, November 1844. Samuel I. Douglas. Footnote: Douglas Samuel I. emigrated to Florida when it was a territory and was appointed in October 1841, confirmed February 1842 as United States Judge for the Middle District of Florida. End of footnote. Judge. Footnote: Florida was at this time a territory, not being admitted into the Union until the following year, and a system of territorial courts, as distinguished from strictly federal courts, was in force until such admission. The judicial power of the territory was vested in a court of appeals, superior courts, and such inferior courts as might from time to time be established. The territorial court corresponding to our United States District Court was that of the Superior Court, the jurisdiction being practically the same. In 1844, the territory was divided into 4 districts: Eastern, Western, Middle, and Southern. End of footnote. November 11th. The prisoner, having been previously indicted, was arraigned and pleaded not guilty. 4 indictments were returned, and they charged, respectively, that he feloniously and unlawfully did aid and assist to run away, or did steal, take, and carry away 1. A Negro man-slave named Silas Scott, of the value of $600 of the goods and chattels of one Robert Caldwell. 2. A Negro man-slave known by the name of Anthony Catlett, of the value of $600 of the goods and chattels of Bird C. Willis. 3. A certain Negro slave named Moses Johnson, of the goods and chattels of Robert C. Caldwell, of the value of $600, and 4. One Negro man-slave named Charlie Johnson, of the value of $600 of the goods and chattels of George Willis. The Court. Prisoner, have you counsel? The prisoner. I have not, and my means are too limited to provide counsel, but I am daily expecting advice from friends in regard to that point, and I request that my trial may be put off for a few days. The Court. If you are not able to provide counsel for yourself, I will provide you one. You may choose any one of the 3 lawyers here to defend you. The prisoner. I would like to have the trial put off a few days, and if at that time I am not provided with counsel, I shall be glad to avail myself of your honor's offer. The Court. The trial will be adjourned for 3 days. November 14th. The prisoner being brought into court stated that, not having any information from his friends as he had hoped, he would choose Mr. Benjamin D. Wright, a member of the bar, to defend him. The jury was impaneled, and the prisoner pleaded not guilty. Walker Anderson, District Attorney for the United States. Footnote: Walker Anderson, the District Attorney, who, by the by, was the prosecuting officer, is entitled to my thanks for his kindness and humanity towards me, both in his private and official capacity. He is a mild, considerate, and intelligent man, and were he not surrounded by a powerful slavery influence, any society might be proud of such a member. I have, for a number of years, known him, and can say that he is of the most amiable disposition of any person I ever knew in Pensacola. For a considerable part of my confinement, he furnished me with reading matter and the news of the day. In his absence, his kind and amiable wife would supply me with literary food. Walker's Life, page 66. End of footnote. Mr. Wright objected to the prisoner being put on trial on 4 indictments for 1 act of offense, if it was an act at all. Mr. Anderson replied, but the court decided that in order to come at the subject properly, 1 indictment should be tried at a time. The evidence. Robert C. Caldwell. Am 2nd Lieutenant in the United States Navy. I accompanied the District Marshal to the steamboat General Taylor at the Navy Yard to conduct the prisoner to Pensacola. In conversation with me, prisoner said that Silas came to his boat a little below the city and got in with some others, but that he did not know him and did not recollect ever seeing him before. This I believed to be correct, for it agrees with what the boy, Silas, had told me. Prisoner said that he had for a long time been of the opinion that he would aid slaves to secure their liberty if opportunity offered. Richard Roberts. At daybreak on the morning of 8th of July, about 5 leagues to the westward of the light ship on Carryfoot's Reef, I fell in with the prisoner and 7 black men in a boat. Was suspicious that the black men were runaway slaves, went alongside boat with my vessel and told my mate to make fast to the boat and requested prisoner and the black men to come on board my sloop. Said I was bound the same way and would give them a tow. Found out by some of the black men that they were runaway slaves. Consequently, I took them all to Key West and delivered them up to the authorities there. Prisoner was sick at the time. He wanted me to let him have his boat and go his way, but I refused. The jury returned a verdict of guilty. The other 3 indictments were then submitted to them, on which they returned a verdict of guilty. The sentence was that the prisoner should be branded on the right hand with the letters SS, should stand in the pillory 1 hour, should be imprisoned 15 days, and should pay a fine of $150. November 16th. This morning at 10 o'clock, the prisoner was placed in the pillory which stood opposite the courthouse by the United States Marshal Ebenezer Dorr. Footnote: the Marshal of the District, Ebenezer Dorr, was formerly from the state of Maine, with whom I had been well acquainted for 8 or 9 years, and we had always been on terms of friendship. But now our mutual feelings were about to be tested, for circumstances having rendered our situations very different. There was no more equality. He was a practical slaveholder and a strong advocate of the system. I, an uncompromising opponent of American slavery in all its forms, he holding a high office under the territorial government. I, a prisoner for a violation of a territorial law, placed in his custody and subject almost entirely to his control. Walker's Life, page 64. End of footnote. He was made sport of by the crowd, and George Willis, the owner of one of the Negroes and United States Marshal of the Western District of Florida, threw 2 eggs at him, which took effect on his head. After the expiration of an hour, he was taken back to the courtroom and placed in the prisoner's dock. The marshal tied one of Walker's hands to the post, and then, again to quote from the prisoner's narrative, took from the fire the branding iron and applied it to the ball of my hand and pressed it on firmly for 15 or 20 seconds. It made a spattering noise like a handful of salt in the fire as the skin seared and gave way to the hot iron. The pain was severe while the iron was on and for some time afterwards. There appeared but few who wished to witness the scene, but my friend George Willis placed himself where he could have a fair view and feasted his eyes on it, apparently with great delight. Walker was then taken back to prison, where he remained until the next June, when a sum of money sufficient to pay his fine and costs, and sent by his abolition friends in New England, reached Pensacola, and he was at once released. He sailed from Florida on the 16th of June, and on the 10th of July arrived at Boston and was received with much enthusiasm by the friends and supporters of the anti-slavery cause. Footnote: during his imprisonment, there were frequent appeals to the Florida authorities by the anti-slavery societies of England and America, and one of these, containing charges of ill treatment, was transmitted by the governor of Massachusetts to the governor of Florida. It was referred to the legislature of the state and was the subject of a report by a joint committee of the House and Senate. The committee treated Walker as a common lawbreaker, contended that he was justly punished, and recommended that slave stealing should be made a capital crime, which suggestion was afterwards adopted. End of footnote. End of section 97.
Section 98 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3, by John D. Lawson. Trial of Antonio Ancarola for kidnapping, New York City, 1879, Part 1. The narrative. For many years prior to 1880, there existed in Italy a class of adventurers calling themselves padroni. They usually acted in pairs and worked alternately 6 months in Italy and America. They obtained children in the Neapolitan districts of the Italian kingdom by a contract with the parents to pay a fixed sum for the services of the children at the end of several years, and they agreed to clothe and feed them during that period and to teach them to sing and play on musical instruments. The parents, who were wretchedly poor with large families to support, would listen greedily to tales of readily acquired riches in America, and would part with the children under these contracts upon the payment to them of a small sum in advance. The children were then shipped from Naples to Marseille. From there they were made to walk the entire way through France, singing, playing, and dancing in the towns and villages through which they passed, to some seaport where they were shipped to America. On landing at New York, New Orleans, or some other United States port, they were brought to a rendezvous, usually in some of the city slums, whence they were sent into the streets by the padroni by day to play or to pretend to play on musical instruments, singing and dancing, and at night they were compelled to perform in the lowest dens and concert saloons. On their return to their temporary abode, they were compelled to deliver up the whole of their earnings to the padroni, of whom they stood in great awe, being threatened, beaten, and starved if they did not bring back enough to satisfy them. No portion of this money ever reaches the parents. It is squandered by the padroni in dissipation or hoarded for their private enrichment. The result is inevitable. The girls become prostitutes at an early age. The boys learn to steal. Both are soon worn out by the life they lead, by the exposure and bad food. Finally, they end in the hospitals and potter's field. These helpless little children could neither speak nor understand English. They were not only dependent for their subsistence upon these padroni, but were unable to appeal against them even if they dared to do so. Told to say that their padrone was their father or brother or other relative, and to give false names both for him and themselves, they were threatened with punishment if they told the truth on any of these points. Hence, it was extremely difficult to derive from them even any correct information of the circumstances under which they were brought to this country. By vigorous efforts of the English Society for Organizing Charitable Relief and Repressing Mendicity and the Italian Benevolent Society, the traffic in England had been well broken up. The Italian government in 1873 enacted a law to prevent this inveigling of children from their homes. In 1874, the Congress of the United States passed an act making it a felony for anyone to knowingly and willfully bring into the United States or the territories thereof any person inveigled or forcibly kidnapped in any other country, with intent to hold such person so inveigled or kidnapped in confinement or to any involuntary service. In September 1879, the New York Society for the Prevention of Cruelty to Children received from the Italian government information that a padrone named Ancarola was about to bring to America a number of children. A close watch was kept for several weeks on all steamers and vessels from Europe, but no trace of the parties could be found, and the search was almost given up as hopeless, when another dispatch was received through the Italian Consul General at New York, stating that Ancarola had left Marseille with 7 boys. In November, upon the arrival of the steamer Alicia from Liverpool, among her passengers were found 7 boys, but the padrone succeeded in evading the officers and disappeared. The boys, ranging in age from 9 to 13 years, were detained and taken in charge by the Society's officers. They all at first told the same story. Each of them said he had an uncle in Montreal, Canada, whither they were going. This story, after being assured of protection, they admitted was false, and had been taught them by the padrone, Ancarola, with threats of severe punishment if not adhered to by them. Nothing was heard of Ancarola for several days, and the Italian quarters and the city were placed under espionage by the Society's officers, who, a week later, discovered him in a wine shop near the docks. He was indicted under the federal statute, tried, found guilty by the jury, and sentenced to 5 years' imprisonment. The trial. In the Circuit Court of the United States, Southern District, New York City, December 1879. Honorable Charles L. Benedict, Judge. December 10. On November 8, Ancarola was brought before Commissioner Lyman, who on November 21 held him in $5,000 bail to await the action of the grand jury. The grand jury, having found 7 indictments against him for a violation of the Acts of Congress, to protect persons of foreign birth against forcible constraint or involuntary servitude, the prisoner was arraigned on 3 of these indictments, consolidated into one, and pleaded not guilty. Stuart L. Woodford, United States Attorney, William P. Fierro, Assistant United States Attorney, Elbridge T. Jerry and Louis L. Delafield, and M. Taylor Pine for the government. Colonel Spencer for the prisoner. December 18. The jury was impaneled and the examination of the witnesses began today. Mr. Fierro opened the case with a brief statement of the facts he expected to prove. The evidence. Mr. Jackson. Am superintendent of the immigrant depot at Castle Garden in this city. The prisoner landed here on November 2nd on a steamship Elysia from Europe, having with him 7 boys. Of this number were the 3 boys here. Asked him if those children were with him. He said they were. Asked his name, and he told me Ancarola. Brought him up to the register's desk, and he registered their names. Asked him where they were going, and he said to Montreal, to their relatives there. Brought them inside then, and he handed me their passage ticket to Montreal as evidence they were going there. The children were not allowed to go with him. He was arrested on November 8th. Francesco Libinati. Was born at Calvello, Italy. My mother is living there, father is dead. Was working in a blacksmith's shop for 2.5 cents a day, making nails. Have 2 sisters and a brother in Calvello, and a brother and a cousin in New York. Our family is poor, cannot play upon any musical instruments. Father had gone to New York and had died there. Being at the shop in Calvello, was sent for by mother and went and found her with her brother and the prisoner. Mother asked me if I wanted to go to America, and I said yes. Uncle said go to America with this man. I said yes. Prisoner said to mother, will you give me your son? She said yes. He said to her I was to play the harp in Chicago. I said that I wanted to play the violin, but he said that I must play the harp, then said that I would play the harp. I went with my uncle to Naples, then to Marseille and London with another boy. At London met prisoner and other boys, and we all came from London to New York in the steamer. On the way over, prisoner said to the boys, if we get arrested, say we are going to Montreal. Have no relatives in Montreal. Michel Quirino. Am 12. My mother is living. Father died in New York. Was born in Calvello, Italy, and lived there. Am a relative of prisoner. Have a sister. Our family is poor. Did not work at anything, but went to school. Me and mother. Uncle and prisoner being together at Calvello, it was agreed between mother and prisoner that I was to be 4 years and a half with prisoner in Chicago, and that prisoner was to give mother 40 ducats. Prisoner said, you live 4.5 years with me, and I will teach you the business, and whatever money you make, you will give to me. Mother said, if you want to go, go. I don't want to compel you to the contrary. Uncle said the same. Prisoner told me I would have to learn the violin, and that I would be clothed and fed. I said I would go. Uncle took me from Calvello to Marseille. There we met prisoner, who took me to London and to New York in the steamer. On the way over, prisoner told me to tell everyone that I was going to see my uncle in Montreal. Have no uncle in Montreal. Giosu Guerreri. Am 11 years old. Father and mother are living in Calvello, Italy, where I was born. Have a brother and a sister. Mother proposed to prisoner to take me to America. Prisoner had just returned from there. He said that America was a good place, and he talked of the beautiful things of America. He said to father and mother, if you let your son go with me, he will do very well in America and send you plenty of money by and by. He said several times that America was a good place, and that they would make plenty of money there, and that they were going to make money for them. I was to work, and all the money I was to give to the prisoner. Prisoner was to take me to Chicago and to teach me music, and from Chicago he would take me further. This was said to my parents. They told prisoner not to ill-treat me and to feed me properly, and that if they should get a letter from me saying that I was not properly treated, they would come and take me away. It was then agreed that prisoner should give father 80 ducats, and that I should go with prisoner for 4 years and be fed and clothed by him, and taught music. Went to Marseille, and there prisoner found me. On the way to New York, in the steamer, prisoner said to me, let us pray to God that we can pass through New York all right. After that, I will teach you music. He gave me a paper with an address in New York where to go, and told me not to let myself be seen by any officer, for they might arrest me. And if anyone asked me what I was going to do not say that I was going with a padrone. He also told me if anyone asked me what my business was, to say that I was printer, and if they asked where I was going, to say I was going to Montreal, and if they asked to whom, to say an uncle. Did not have an uncle in Montreal. Mr. Fierro. Gentlemen of the jury, as counsel for the United States in this case, I beg leave to assert, calling the court to witness as to the truth of the assertion and challenging counsel to its refutation, that in the Circuit Court of the United States, where questions of the greatest magnitude, affecting the property and lives of individuals and the very existence of the government itself, have been heard and determined, no case of more vital interest has ever been occupied the attention of court and jury. I am speaking earnestly, gentlemen, yet I trust no more so than the occasion demands, and I beseech you that when after the charge of his honor, in which the law governing this case will be defined and explained, you shall have retired to the privacy of your consultation room, it may be the determination of each and every one of you to adjudicate between the prisoner and the government according to the law and the evidence as you have been sworn to do. Having in mind that while as to the accused you simply say by your verdict guilty or not guilty, at the same time, for the first, and it may be the last time, you endorse and give force and effect to, or you repudiate and nullify one of the wisest statutes ever enacted for the protection and enforcement of right and the redress and prevention of wrong. As I briefly stated in the opening, gentlemen of the jury, for a long number of years this heartless and inhuman traffic in little children has been carried on between this country and Italy. Wise and good men of this and other countries, beholding the sad spectacle of these little wanderers in America and their pitiable state, have heard singing in their ears the Macedonian cry, "Come and help us." In response to that cry, they have earnestly labored to suppress this nefarious business through moral and educational influences. The wrong of it in every regard has again and again been demonstrated, but all this has been in vain. Still the traffic continues. It increased with the welcome multitude pouring through our broad gates from all the nations of the earth, grafting the qualities of older stock upon one stem, mingling the blood of many races in a common stream, and swelling the rich volume of our English speech with varied music from 100 tongues. The native land of the discoverer of this country sent forth its children to recruit the ranks of the rambling street musicians, Arabs, mendicants, and thieves of America. The law was finally invoked, and on the 21st day of December 1873, the act, a copy of which I now hold in my hand, and which has, notwithstanding the objection of the defense, has been introduced in evidence here, was passed by the Senate and Chamber of Deputies at Rome. This law is entitled Law on the Prohibition of the Employment of Children in Rambling Trades, and it was clearly the intent of its makers to protect its children and stop this trade. It is the most severe of all the so-called Padrone statutes, and provides generally that any person who shall take abroad or allow or seduce from Italy any child under 18 years of age to engage as a musician or singer shall be subject to fine and imprisonment, that any guardian or parent who shall entrust or deliver to another any such child for such purpose shall be punished by fine and imprisonment, that any persons who have allowed children to be taken away from the kingdom shall immediately notify the mayor of the community where they reside, who shall make a catalogue of such minors to be transmitted to the royal representative of Italy in the countries where the children are. Such representatives shall make a catalogue of such minors, and have the names and residences of the persons in whose charge they are, and all such children shall be returned to the kingdom of Italy. This law is so sweeping in its provisions that it not only makes the parent or guardian amenable to punishment, but it also makes whoever shall suggest or intimate, or whoever shall even assist in suggesting or intimating that a child of the age mentioned should be taken from Italy abroad for the purpose of employment in the different rambling trades herein denounced, amenable to the same punishment by heavy fine and long terms of imprisonment. This law also has another pertinent provision, one which of course counsel has carefully attempted to conceal, for it sweeps fore and aft the entire case. It sweeps away this so-called contract, and at once annihilates the proposition he has advanced that the evidence shows a legitimate bargain was made by this padrone with the parents and friends of these 7 children, and that you must find the contract binding and send him from this court acquitted of these indictments. I read Section 8 of this Italian law. Quote, whatever contract of trusting or committing in any form it may be disposed for one of the purposes mentioned in Sections 1 and 3, either made before or after the publication of this law, is null and of no effect, however the scope may have been concealed or simulated in whatever way, in either to interpose endorsements in the kingdom or abroad. End quote. What does this section mean when applied to the case at bar? What it means, if it means anything, is that this was an entirely illegal performance on the part of this wicked, cunning padrone, that he had no right to the consent of the parents or friends, that he was knowingly violating the Italian law, and it necessarily follows that the court will charge you, gentlemen, that these children were both unveiled and kidnapped. Then, gentlemen of the jury, on the 23rd day of June, 1874, Congress passed the act under which the prisoner has been indicted, and his trial had, and which reads as follows, quote, "Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that whoever shall knowingly and willfully bring into the United States or territories thereof any person unveiled or forcibly kidnapped in any other country, with intent to hold such person so unveiled or kidnapped in confinement or to any involuntary service, and whoever shall knowingly or willfully sell or cause to be sold into any condition of involuntary servitude any other person for any term whatever, and every person who shall knowingly and willfully hold to involuntary services any person so sold and bought shall be deemed guilty of a felony, and on conviction thereof be imprisoned for a term not exceeding 5 years, and pay a fine not exceeding $5,000. End quote. The New York Society for the Prevention of Cruelty to Children secured the passage of a similar statute in this state and in several other states, and it is now making every lawful effort to enforce these laws and to stop the importation of and cruelty to these poor, helpless, and homeless little waifs. But this, as I have previously intimated, is the first prosecution under the United States statute. So that you will readily observe, gentlemen, that the great overshadowing question you must answer now and here is, has this all been in vain? I repeat, through your action in this case, by your verdict here, you say to the country and the world, remember, you cannot evade the issue. For if we have no case now, none can ever be made. You say there is no help. You are powerless, or you declare that the law can and shall be enforced, and the padrone's occupation must cease now and forever. I would not forget to so far notice the allusion counsel has frequently made for the past 2 days to the strong representation of the Society for the Prevention of Cruelty to Children at this trial, as to say that it was in kind response to my invitation, so to do that the honored president, the consul, with the efficient officers, Superintendent Jenkins, and Mr. Cherardi, have attended in court and have rendered the government very material aid in the marshalling of evidence and the general conduct of this case, for which they merit and will doubtless receive the thanks of all good people, no matter what may be the result of this trial. Of course, this makes neither one way or the other with you, gentlemen, for you will decide this case on its merits. As the court will instruct you, there are but 3 simple questions to answer in arriving at your verdict, and I am sure that you will find no difficulty with either. First, were these children unveiled or forcibly kidnapped in Italy? Of course, as you will observe, gentlemen, it is not necessary that the government should show that the prisoner unveiled or kidnapped the children. These acts may have been committed by another, but the prosecution must satisfy you beyond a reasonable, not an unreasonable doubt, that the accused knew they had been so unveiled and kidnapped. Now, gentlemen, you have heard the sad stories of 3 of these little boys, Francisco Libonati, 11 years of age, Michel Quirino, 13, and Gisui Guerreri, 11. And it is all fresh in your minds, so that it is unnecessary for me to rehearse. As I have already said, the law of Italy, absolutely prohibiting the assent of parents, guardians, or children, it follows that the children were unveiled or kidnapped, and it is confidently claimed that they were both unveiled and kidnapped. You remember how this padrone operated to obtain control of these children, and that he effected his object by cunningly holding out different inducements, by resorting to artful persuasions, and by the use of money. Yes, gentlemen, strange and revolting as it may seem to us, at this day these unnatural parents actually sold their offspring into involuntary servitude for a few dollars. This has been conclusively shown, and therefore 2 counts in each of these indictments have been thoroughly sustained, and his conviction must follow. But further, take the evidence of the boy last on the witness stand, the exceedingly bright little Gisù Guerreri, only 11 years of age, and when he tells you, through the interpreter in his simple way, that Ancarola himself had several talks with his parents and the boy, at which Ancarola actually urged them to take him from school to go with him, told them America was a good place to make money, and the boy would soon be sending money home. Then he made a written contract for the boy, whereby he was to go to America with Ancarola and stay with him for 4 years and 6 months, to play the violin in Chicago and elsewhere, Ancarola to receive the earnings, that his parents refused to let him go unless money was paid, and Ancarola then gave them 100 francs. that no one was present except the boy, his father and mother, and Ancarola, that Ancarola cunningly arranged to have the boy delivered to him outside the kingdom and paid his passage over, that he cried at leaving home and friends, that on the ship Ancarola told him to say if anyone asked him where he was going, that he was not going with Ancarola, the padrone, but that he was going to an uncle in Montreal, that he had no uncle in Montreal, that he told Ancarola's falsehood at Castle Garden, but on the assurance of the Italian consul that Ancarola could not harm him, told the true story of his unveilment and kidnapping from Italy. I repeat, gentlemen, when he related all this and counsel admitted it to be true, having failed to shake him on cross-examination, did you doubt that his first question must be answered in the affirmative, and that Ancarola himself was guilty of the unveilment and kidnapping? These padroni are cunning. Most cunningly they endeavor to evade the law in the inception of their business, and then, when finally caught, accused, and arraigned before the court, can well afford to employ expensive and sharp counsel to execute their well-planned defense. But in this instance the well-laid and oft-tried scheme has miscarried. The padrone, Ancarola, cannot now escape. Out of the mouths of these children he stands condemned before you. The second question, gentlemen, did the prisoner, Ancarola, bring these children into the United States, can be answered in the affirmative without leaving your seats. Then you will come to the third and last question. Did he intend to hold them to any involuntary service? Now I apprehend, gentlemen, that the court will charge you as matter of law, that these children were too young to consent to any service. They cannot voluntarily submit themselves to any service. It must be involuntary on their part, and that the premeditated violation of the Italian law by this padrone and the character of the employment may be taken into account in this connection as bearing on his intent. I may, however, erroneously anticipate the direction of the court in this regard. Be that as it may, I am convinced that you cannot find, as you must if your verdict be that of acquittal here, that he simply brought these boys to America on a pleasure excursion or to visit friends, and they could return home if they so desired by the very next steamer, without any hindrance of the prisoner. But on the contrary, you must conclude on the uncontradicted, unimpeached, and unimpeachable evidence that he intended to hold them to an involuntary service. That is to say, that he purposed employing them under his so-called contract, whether they would be so employed or not. For what purpose did he solicit the boys to come with him to America in violation of this Italian law? Why did he pay all their expenses to America? Why did he pay their friends money? Why did he secure them to himself for 4 years and 6 months to play on the violin and harp? Why was he to receive the money they earned? Why did he put the lie into the mouths of these boys on the passage to America, and why did he conceal himself and try to escape arrest in the city of New York? I ask, why did he do these and other things I have no time to call to your immediate attention if he did not intend to hold them to an involuntary service? No, gentlemen, there is no escape from the conclusion that this was the padrone's intent. He has been frustrated and now asks you to say that there is no evidence, but that he intended the boys should act at their own pleasure on their arrival in America. Of course, this is ridiculous beyond comparison, and only finds it parallel in the assertions of counsel made for effect upon you, that there is no proof of maltreatment of these children by the padrone. No, the element of treatment, one way or another, has never been in the case. Therefore, you will only be required to say, in order to convict, that he intended to do and carry out the simple terms and conditions of his so-called contracts, the statement of which the accused himself admits to be true. It is idle to argue a proposition where we are all at one. Gentlemen, therefore, I abruptly halt here, and with its dismissal submit the case to you. This prosecution being entirely new, there are no decisions of state or federal courts directly in point. I have, however, called the court's attention to all the authorities I have found bearing either directly or indirectly upon the questions raised in this case, as to the unveilment, kidnapping, and involuntary service. Congratulating you, gentlemen of the jury, upon the speedy termination of the trial, and believing your verdict will be both early and just, I close on behalf of the government. End of section 98. Section 99 of American State Trials, Volume 3. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. American State Trials, Volume 3 by John D. Lawson. Trial of Antonio Ancarola for Kidnapping, New York City, 1879, Part 2. December 19. Judge Benedict. Gentlemen of the jury, it is difficult, I think, for any thoughtful person to take part in the decision of a criminal case without a sense of responsibility. The interest of the community in the proper enforcement of the criminal laws is such. The misfortune is so great when an effort to bring an offender to justice miscarries. The misfortune is so great when one innocent is adjudged guilty that the responsibility attaching to the judge and to the jury, also in cases of this description, seldom fails to make itself felt. It cannot fail to be felt in a case like the present, where the prosecution is under a statute now, for the first time, so far as I know, sought to be enforced. The language of the statute is as follows, quote, "Whoever shall knowingly and willfully bring into the United States or the territories thereof any person inveigled or forcibly kidnapped in any other country, with intent to hold such person so inveigled or kidnapped in confinement or to any involuntary service, shall be deemed guilty of a felony, and on conviction thereof be imprisoned for a term not exceeding 5 years, and pay a fine not exceeding $5,000. End quote. The accused is charged with a violation of this statute in regard to the 3 children who have given testimony before you. The charge against the accused is not that he, in Italy, inveigled these children, nor is it that he has held these children in confinement, or to an involuntary service in this country. Such acts have not been made offenses by any statute of the United States. The act to which the statute makes an offense is an act done in this country, namely the act of bringing into the United States a person inveigled in another country, with intent to hold the person so brought in confinement, or to any involuntary service. And the charge against the accused is that he did this act, namely, that he brought these children into the United States, knowing that they had been inveigled in Italy, with the intent to hold them in confinement or to involuntary service, as beggars and musicians. You are called on, therefore, to inquire first whether the accused did bring these 3 children or any of them into the United States. If you find it proved that these children landed from a vessel that brought them to the city from a foreign port in custody of the accused, that the accused had selected the mode of conveying them and directed the movements of the children in coming here, you may find that the children were brought into the United States by the accused. If you find that the accused brought the children into the United States, your next inquiry will naturally be whether these children, or any of them, had been inveigled in Italy. There is no evidence that would warrant you in finding that these children had been kidnapped in Italy, and your inquiry at this point therefore be confined to the question of inveiglment. The testimony bearing upon this question is so nearly alike in regard to each of the children that it will be unnecessary for me to distinguish between the cases, leaving you to consider the evidence in regard to each child and to notice any differences that may have been disclosed by the testimony. The testimony that has been given in your presence, the truth of which has been admitted to you in behalf of the accused, is to the effect that a bargain was made in Italy between the accused and the parents of the children respectively, by the terms of which the accused was in each case to pay the parent a certain sum of money, in one case less than $10, I think, and in consideration thereof the child was to be delivered to the accused, to be taken by him to this country for the purpose of being here employed for the benefit of the accused, in one case as musician in Chicago, in another to play the violin in Chicago, and in the other to be taught music in Chicago, and from Chicago to be taken further. To this arrangement the consent of the child was in each case obtained, and in one of the cases, after representations by the accused to the child in regard to the beautiful things of America. In pursuance of this arrangement made in Italy, the child was taken to Naples, in one case by an uncle, and from Naples sent to Marseille. There these 3 children with 4 others were taken in charge by the accused, and thereafter came with him to this city. One of the children is 11, another 13, and another 11 years of age. In connection with the evidence in respect to the arrangement made in Italy, it will be important for you to consider the law of Italy relating to the employment of children in wandering professions. But it must be remembered that the accused is not on trial for violating the law of Italy, and cannot be found guilty by you because of any violation of the law of Italy that you may believe to have been disclosed by the evidence. He must be found guilty, if at all, for a violation of the laws of the United States that you have heard read. The law of Italy has been admitted in evidence as bearing upon the question of inveiglment, and solely for the purpose of showing the character of the act to which the consent of these children was obtained in Italy. The law of Italy provides as follows. Section 1. Any person who shall entrust, or under whatever pretense, shall commit to natives or strangers other persons of either sex under the age of 18 years, though his or her own children or pupils, and any native or stranger who shall receive them with the intent to employ them in the kingdom, in whatever manner or under whatever denomination, in the practice of wandering professions as saltimbancs, witches, charlatans, errant players or singers, rope dancers, guessers, fortune-tellers, animal exposers, beggars, and similar wanderers, shall be punished with the imprisonment from 1 to 3 months, and fined from 51 to 250 lire, etc. Section 3. Anyone who shall trust or deliver in the kingdom or take abroad in order to trust or deliver to natives or strangers abroad, persons under 18 years of age, though his or his own children are pupils, and any native or stranger who shall receive such persons, in order to take trust or deliver them abroad for the purpose to employ them, in whatever way and under whatever denomination in the practice of wandering professions as shown in Section 1, shall be punished with imprisonment from 6 months to 1 year, and fined from 100 to 500 lire. You will observe that the arrangement to which the assent of these children was secured in Italy was unlawful, provided the children were to be employed in a wandering profession, such as errant players or beggars, or similar wanderers. It has been contended here that these children were not intended to be employed as wanderers in violation of the law of Italy, because the evidence is that they were to be employed to play a harp or be musicians in Chicago. But, gentlemen, a child of 11 or 13 years of age may be a wanderer in the streets of a great city, and if, upon considering the evidence and what has been proved in regard to the character of the arrangement made in Italy, and the age of the children and their ability to earn money for the accused by labor, you conclude that the arrangement made in Italy in regard to these children, or either of them, contemplated the delivery of these children to the accused to be by him brought into this country for the purpose of being employed as beggars or street musicians in Chicago, and that the child was then and there entitled to consent to such an arrangement, then you will be justified in finding that such child had been unveiled in Italy. The statute of the United States contains the word knowingly, and renders it necessary, in order to convict the accused, that you should find that he brought the children to this country knowing at the time that they had been unveiled in Italy. The evidence in regard to this knowledge, in regard to any unveilment of the children, is to be found in the testimony respecting the part he took in making the bargain with the parents and the obtaining of the consent of the child. The next subject of inquiry is important, for it relates to the intent. In order to a conviction, it must be proved not only that the child had been unveiled in Italy to come to this country in charge of the accused, and was brought here by the accused with knowledge of what had transpired in Italy, but it must also be proved that the accused brought the child here with the intent to hold the child, when so brought, in confinement, or to involuntary service as a beggar or a musician. This intent is a necessary ingredient of the offense and must be proved as laid. The children were taken from the accused immediately upon landing from the steamer, and it is perhaps best to consider the evidence as insufficient to justify finding an intention to hold the children in confinement. The question rather is, did he intend to hold them to involuntary service, as beggars, or as musicians? Upon this question, the age of the child is important, for as you know, in regard to some things, a child of such tender years is incapable of consent. The nature of the employment to which the accused intended to put the child, the evidence in regard to the arrangement made in Italy, and the ability of the child to labor or play an instrument are important circumstances in the connection also. For, if you believe from the evidence that the intention of the accused in bringing the child to this country was to employ the child as a beggar or as a street musician for his own profit, and that such employment was one injurious to its morals and inconsistent with its proper care and education, according to its condition, then you will be justified in finding that he intended to hold such child to involuntary service as charged in the indictment, and this notwithstanding the fact that the child had consented to the employment in Italy, and that no evidence of a subsequent descent while under the control of the accused has been given. I have now, gentlemen, called your attention to the question of the fact which you are called on to determine. The case is considered by the government to be important, and such it is, but it is to be determined upon its own facts as they have been proved by evidence, and not upon any general notion in regard to the necessity of punishing padroni and putting an end to traffic in children. The accused is entitled to have his case determined upon its own facts, and without any prejudice against him by reason of any supposition on your part as to what others may have done. It is a criminal case, and the accused is entitled to the benefit of any reasonable doubt in regard to the existence of any of the facts that have been pointed out as material. You must give the accused the benefit of the doubt and acquit him. If you have no doubt and are satisfied as to these facts by the evidence that has been given, you must convict him. The verdict. The jury, after a short deliberation, returned a verdict of guilty of the several offenses charged in the indictment, and Ancarola was remanded for sentence. January 12, 1880. The prisoner's counsel having moved for a new trial before Judge Blatchford, and a new trial having been refused, the prisoner appeared today for sentence. Judge Benedict. The prisoner at the bar has been duly convicted of the crime of bringing into this country certain persons inveigled in another country, with intent to hold such persons to an involuntary service. The punishment prescribed by the statute for this crime is imprisonment for a term not exceeding 5 years, and a fine not exceeding $5,000. The conviction was had upon 3 indictments, charging 3 separate offenses, and there was evidence tending to show that the prisoner was liable to conviction upon 4 other similar indictments on file in this court. He not only brought into this country the 3 boys of tender years mentioned in the indictment, upon which he was tried, but also 4 other boys under like unlawful circumstances. There was no ignorance on the part of the prisoner respecting the character of the transactions in which he was engaged. The law has been upon the statute book for several years, and the evidence given at the trial showed actual knowledge by the prisoner that he was violating the law. My attention has been called on behalf of the prisoner to the fact that this is the first conviction under the law. It is the first conviction, but I do not know that it is the first violation of the law. My desire on this occasion is to inflict a punishment that will tend to prevent violations of this law in the future, and it may be make this the first conviction, also the last. I am anxious to avoid undue severity, and at the same time so to administer the law in this case as to prevent the commission of similar crimes by others. The sentence of the court upon the indictment numbered 1 for the offenses therein charged is that the prisoner at the bar be imprisoned for the term of 5 years, and pay a fine of $1, the sentence to be executed in the Albany Penitentiary. The sentence upon the 2nd and 3rd indictments will be suspended. End of section 99. End of American State Trials, Volume 3, by John D. Lawson.